Well, good evening. Happy Friday to everyone. It is about 10 minutes late. So, not as late as I usually am, but still late nonetheless. But happy Friday. It is May 3rd, 2024. It is indeed May. It's going to be May. It is May. Um, and it's been a wild week. This is the first FNF I am doing in my 41st year of life. So I'm happy to be doing that. How you guys doing? How was your week? Want to hear from you guys for this little bit. I know that I haven't done that in a while. What are you guys up to? How was your week and what are you drinking? Where are you tuning in from? Kind of miss doing that. So hi to all of you in the chat. We already have some gifted memberships. Thank you, Pamela Weisenbach, for the gifted memberships, and Laura Christine for the gifted memberships, and Patty Hoffman coming in with a $20 super chat. Wine and Leo treats. Leo gets a lot of treats as it is. Rideman YYC coming in with gifted memberships, as well as Bop It and Midnight Dreary. You guys are awesome. Always flooding the chat with some love. L444, thanks for becoming a member. Much appreciated. And Baby Steps. Very tuned. Hi, Rob. Hope you're feeling lots better. We missed you. Happy belated birthday. I'm doing a little bit better. Still struggling with whether it's cold or allergies. I can't tell. It's like a chest cold so we're going to do our best today, but I will try to mute the microphone when I get into a coughing spell. It's been a week. It's been like a solid, really crazy week. So Patty P, Southampton, New York, with some Diet Sprite. That's awesome. Hope you're doing wonderful. Blackberry mocktail. It's a mocktail. Izzy Soda just got some and loving it. I haven't had that in forever. Haven't had that in a long time. Amanda Lang drinking tea in southern British Columbia. Catherine is having Pepsi in Charlotte. So we got Charlotte, British Columbia. We have Ontario, Canada in the house. We got some Boston and drinking some water. Well, you might need something stronger after witnessing half of what happened in Boston this week with the Karen Reed trial. Carla Barrick, I'm a legal assistant, so tired, but keeping up with the Karen Reed trial. I have been doing my best. I have been stressing over a lot of the what if any. Today, I heard what I thought was impossible. I heard what if any used twice in the same question. And my brain broke. It just shattered. Oh, there's a whole lot of patience that you have to be doing that. It is pretty wild. So let's see. Oh no. Paralegal Liz, we have 2 rule to show cause hearings. That's 2 motions for contempt. One of them expedited. I'm done. I had a 3-day trial scheduled to begin Monday, Tuesday, Wednesday, followed quickly by turnaround for prep for a trial the following week. At the same time, this house is getting ready to sell. I don't want to do this again. I don't want to sell a house again. I don't want to move again. The stress involved, I am physically, emotionally, psychologically, all of the other lees, just exhausted. Holy smokes. So yeah, next week, 3-day trial. Day 1 got resolved, but days 2 and 3 are still going forward, Tuesday and Wednesday. And then immediately followed by Packers on day 4 of next week and movers on day 5 to move stuff to storage so the house can get listed. Oh my gosh, make it go away. Just make it go away. So it's going to be interesting. It's going to be a fun next few weeks. I'll tell you that much. So let me start over again. Will the real Ray E please stand up? Thank you for the super chat. Loved the 200K birthday special. What, if any, rules did your old boss break? Just all of them. Thank you guys for tuning into that. That was a lot of fun. I had the very, very sincere pleasure last weekend, even though I did not do FNF, very much needed some recovery time. But let me put it this way. Mischief manager that you see in the chat often, who is my beloved, lies and deceit. Lies and deceit is how we begin my 41st year of life because I was promised and told a very simple outing to Top Golf. A simple outing to Top Golf on Sunday, um, that was supposed to have followed just a friendly get together with some of my best friends, um, for lunch. So drove over there early. When am I ever early? And got a Lego set out of the back of my truck and a lovely little wooden firearm that I was building or intended to build. Because I figured, lunch with friends, might as well bring those things in. Get them out of the truck, go and walk inside the house. And the second I walk inside the house, I notice another friend that I didn't expect to be there was filming. Turn the corner, and there was a gathering of people that were there to surprise me. Now, this had been planned for 2 months, or a month and a half. Lies and deceit. And of course, mischief goes and tells me I was hiding my phone from you. That's one thing. I didn't notice a single damn thing. I was completely caught off guard. And what was even cooler was one, my mom was there. Two, my sister was there. All of my friends were there. And scattered around the house were balloons that were blown up with helium. Suspended from the balloons were photographs of me, family, and friends from throughout the past years of my life. So it was a wonderful, wonderful celebration. It was awesome. I could not have felt more surrounded by love. And seeing the kiddos all run around. It's really cool when the kiddos are all of a certain age and just letting them go out and do their thing. Because it is, one, it's wild to see how their imaginations work. And two, when kiddos are around other kiddos, they just disappear and they let the adults do fun stuff. So it was a great time. It was hot. It has been hot. And yeah, that was a good way to end that celebration and to begin year 41. So it was quite the week indeed. Golden Girls got lime margaritas in Kentucky, PB&J with a blood orange beer. Lovely, absolutely amazing. Ashley D is hi friends drinking Mountain Dew, Baja Blast. Is that really any good? It's not as good from a can. South Carolina. South Carolina's got to be getting hot now too. Henhouse Bath Company, hi from Nashville with Cabernet. Henhouse Bath Company, I also received a box from you that has not yet been opened. It's there. I just got to open it. So I did receive it. Thank you very much. D Whitaker, Mexican Coca-Cola. D Cripple from Alberta is tuning in. South Jersey, drinking some water. Gatorade in Texas. Bobby Graham is feeling how I feel. Allergies. I sound like a baby seal. I don't know if I sound like a baby seal, but I don't feel like myself. I don't feel like I sound like myself. I had a emotions argument this morning. Whoever decided that 8:30 in the morning was a good time for contested arguments, drag them out into the alley. And I'm not going to finish the end of that sentence. For not a morning person, even though the appearance is telephonic, oh my gosh, it's exhausting. But a lot of doing good in court this week, prevailed on a lot of issues, and beginning next week strong, hopefully. So moving on, sparkling water, wonderful. Lemon drop, thanks to Emily from Colorado. Emily, lemon drop, really? Carolina. I don't know what that means. Carolina Hurricanes are doing a lot of hockey. Pinot Noir in Raleigh. Awesome. Cape Breton in Canada. High noon in Florida. You guys are all over the country. Is Runkle napping? Probably. Yeah, I think so. I made the effort. I was texting him earlier today because with this little congestion, I said, it's a good idea? Really hot wings to try and clear that up. It was not a good idea. It was a terrible idea. They were too hot, but they were delicious. I did not use Ian's hot sauce. I have run out of Ian's hot sauce, so I need a refill. Ms. Violet Iced Tea in Ontario, Canada. Awesome. K-Rab, looking forward to meet and greet with my 3 favorite law tubers at CrimeCon and seeing EDB and the Kowalskis who aren't speakers. I am aware of that. Also aware of CrimeCon. And yeah, that'll be a fun trip at the end of May, which, well, we need a whole lot of stars to align for all of that. So just everyone cross your fingers for the alignment of stars. Kate R. Alita is keeping a tally. It is insane. So is Brandy Churchwell. I saw the tally at the end of today was up to 301 what if any's in the Karen Reed trial. Like I said, sanity is, well, it's left the room. It's left the building. Chris, a BS juror, Pepsi in Michigan. We got Michigan in the house. We got Kansas in the house. Pop Princess, my brain broke too. What if any? Yeah, there were a ton of those. Just a ton of those. Central Jersey, beautiful country. Cherry Diet Pepsi. That's something about New Jersey people don't realize. Central Jersey is gorgeous. Let's see. Obi and Vader. Tomorrow's Vader's Gotcha Day. I heard that tomorrow is Star Wars Day, so at midnight we'll have to celebrate that. Justice Jane, what is that radiant thing behind you? That is a child decision made with an adult body. That curtain is a light curtain that I can make do different things. Like, for example, I can make it do flowers. I can make it do a human. There's a human, and
that was not a curtain function.
A human joins the screen. Yeah. How you doing? How are you? Oh, look at this, the screen. There. Oh no, that's the artwork, the screen. So, how you doing, buddy?
Tired. Haven't been sleeping. That said, Zora was insanely cute just earlier.
Yeah.
Because I'm sitting there trying to nap, and Zora's dinner time rolls around. So Zora very much wants dinner. So she has also learned that it is perfectly acceptable to come bother me if I am face up, because I never sleep face up on the bed. But if I'm face down, I am sleep mode, and she should leave me alone. Mm-hmm. So I was playing around with like turning over just to have her go from like, oh, time for dinner to like, oh, I got to leave you alone. And so I was playing with that. And then and so then I'm there, and so I sort of start to sit up, and she bolts towards her dish. I can hear her like patter through the house as she just runs full on towards her dish, including like a leap off the bed. And then, so I'm like, I wasn't quite ready to get out of bed, but that I admire your gumption. And then I hear thumpa, 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 leap as she runs back into the bed. She's like, I thought we were going to the dinner place.
Mm-hmm.
And so then I go and I make like a little gesture in that direction, and she leaps off thumpa, 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 thumpa up to her bowl. And she repeats this like 20 times, because now I'm just finding it a little bit funny. So I go and like lean up a bit, and she's like, oof, off. So I was having a little bit of fun messing with her. And, but yeah, she was super cute. Finally, I get her up to her, like to the dinner bowl, and she's like, is it dinner yet? And I'm like, sit on your spot, because she's got a little mat next to the dinner spot that we make her sit on. And she's just like, ooh, 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 scooch, scooch, scooch.
And
so
you just
she's like so eager.
You see the drool just running down the mouth. Like, I know that there's food about to be in this bowl.
Oh, she's just, you would think that she hasn't eaten in like 6 days, and she is just so tense, like so wound up springs. And I'm going, I'm not going to let you starve, right, dog? So, but yeah, she got her dinner. She got a little bit of a treat. I had some sardines earlier, and one of the things she just loves as a treat is, she gets her dinner and then she gets the sardine oil on top of it. And she was just like, she just loved that.
You and I are just, our food is just never going to align. Ever.
What's wrong with sardines?
In certain settings, like a Caesar salad. Yeah. Yellow
I make like a sardine sandwich out of them with like some nice like toasted rye bread and some capers and some little
That is
finely cut
what
onions.
you talk about. That's enough sodium, Ian. What the heck are you doing?
Oh, I live on sodium and caffeine.
I knew the caffeine part.
And spite, but
yeah,
but
I knew that part too.
I'm mostly a source of that as opposed to a consumer.
Yeah, I have opposing counsel in the case I have for trial next week who really does not like me. Like does not like me at all.
Oh, that's fun though.
Well, it is and it's not. I wish people would understand. I hope people do. When you're an attorney, sometimes you have to play a role. The attorneys and actors have a whole lot in common. They actually teach a CLE, like what can attorneys learn from actors? I don't like the role I have to play with this attorney. I don't like being the bad guy. I really don't. But I have to in order to get anything done in this case. It's impossible. So I keep dishing up wins and she keeps being angry.
I mean, some lawyers just don't get that that yeah, it's not a good strategy to be a jerk. So
and don't take the things that I do in litigation as me. It's not personal. It's not. That's the thing. Disconnect what I have to do in the courtroom and what I have to do for the benefit of my client. Disconnect that from my feelings of you. Don't let that bleed over.
I mean, sometimes it can be a little bit personal.
Yeah, man. I try to avoid that at all costs.
Just sometimes you get a lawyer who just insists on making it personal. And it's like, all right, just so you know,
we're here now.
I respond to it being personal by doing excellent work for my client and just like, going the extra mile. So if you want me to spend like an extra, 30 hours on research, just like not billed to the client, but just because screw you, that's how you do it.
And I love Yellow Pill's note here. I love that you've accepted that we're going to still be here past midnight. Midnight being the tuning in of the reining in of Star Wars Day. Yellow Pill, did you happen to see the docket that I set for myself? Here, I'll give you. This was the thumbnail.
Wait, you have a docket?
Well, these are the things we're slated to talk about.
I like your little Elaine / Lally comparison.
Yeah. And then you got Tom Brady rocking the SBF hair. So no, we're gonna be here past midnight. I'm like 99% guaranteed because there's a lot to cover, and the Karen Reed trial is going to take up some of it. But we have something that we need to celebrate. And it's not my birthday.
We should also celebrate that, though.
Well, we already did that. A very dear friend of ours had a very cool thing happen that was caused large part by the chat, because the chat is awesome and chat's fantastic. So, Stroke Hero Awards.
You're referring to the crushing defeat of Small Cute Child.
I was getting there. So the American Stroke Association has this Stroke Hero Awards that's intended to honor individuals and groups in the stroke community who have shown resilience and outstanding progress. And of the categories, there are the Caregiver Hero, Equity Hero, Group Heroes. We love them. They're fantastic. The Pediatric Hero, the Survivor Hero, and the Voter's Choice Hero, who you guys might recognize. That is Mr. Rick Hogue. Look at that.
And he's doing the gesture of what, if any?
No, he's not. That is not what that gesture is. No, it's not. Take it back. Take it back right now.
I just had to say it just because I knew that would.
Let me see. Did he say what if any in his statement? Nope. I don't see any what if any in there. Nope. But yeah, Rick Hogue destroyed. I think rather resoundingly destroyed Innocent Cute Child.
As is proper and just and righteous.
Yeah. Well, it's just on the topic of the destruction of little cute children. There was.
That's a hell of a topic.
How am I going to transition this one? I went to Mini Mischief 1 when Mini Mischief 1's talent show this week. It's an elementary school talent show. That was something I was not prepared for. You put in your mind what you anticipate out of a talent show of cute little children, and then you see the talent show, and oh my
Do they get
gosh.
competitive?
No, they really do cheer each other on. They know all the words to all the songs, so they're singing things loudly. 2, kudos to the parents that corral these kids and the teachers that corral these kids, because I walked into that little cafeteria auditorium makeshift thing, and my word, herding cats would be easier because the energy, and I don't know what
because it's legal to have cats spayed.
Ian, that took me too long. No, you are not allowed to do those things with humans. Nope. Mm-mm. But also at that age, people say that boys are difficult. The boys were the ones causing problems, man. The volume of all of these elementary school little girls are the loudest thing I think I've ever heard in my life. It just, the car ride after that was the silence that was just the peace. It was amazing. So amazing.
I bought some really good earphones. I should test those out.
Oh, I did learn a joke. I learned a joke so there was a kid that did a stand-up comedy bit. It's really brave, by the way, for a 5th grader to do a stand-up comedy of his own making. So he gets out and he does it, and they don't know how to hold the microphone, so they're holding the microphone sideways, so you can't hear them at all. And it's quiet and but you hear the joke, and the joke was phenomenal. Can I say it? I want to say it because it's golf.
Oh,
so, yeah, you got to suffer through it. You just got to live with it. You got to live with it. Mind you, this is coming out of, and the 5th grader that was doing this had to have been the heartthrob of the elementary school, because he had the heartthrob hair. And as I described the heartthrob hair, I imagine that people are immediately already understanding like the hair that's like over the eye a little bit. Like yeah. So the joke is, kid goes to his dad and says, Dad, someday I'm going to be a famous magician. And the dad surprisingly doesn't say, no, you're not, or anything to that effect. The dad asked the young boy and says, well, what's your first magic trick going to be? And this boy says, well, I'm going to make a golf ball float. And the dad is now suddenly intrigued. And the dad says, you know what? How the heck are you going to do that? And the kid looks back and says, it's no problem at all. I just need 2 scoops of ice cream, a Coca-Cola, and a golf ball.
Yeah, I saw that one coming.
Oh, it was so good. Totally not me laughing way louder than I should have been. But
I saw that one coming. I was like,
oh, it was so good. It was so amazing. So that was the elementary school talent show, which 1, the kids are really talented. 2, can't wait till they become more talented, especially in the singing department. And 3, it was just a lot of fun. So that was the talent show. I do have a request for good thoughts and well wishes to my paralegal, who informed me this week that she actually watches these streams.
Oh God,
scares me. I know. I know. She says that she watches you and I go back and forth for a bit, and then when we get to the topics, that's when she just falls asleep. It's like, that's fair. That's totally fair. But she has a medical procedure coming up this next week. This medical procedure coming up this next week, so she'll be out for 2 weeks. So we're wishing her much success in that procedure.
All the good wishes, paralegal, whose name I don't know, but we don't need to announce it on the stream either. So
now we can call her Mama G. So Mama G.
Good wishes, Mama G. Let us know if there's anything we can do.
Yeah. It was
Rob is going to be more than happy to accommodate whatever requirements you have.
Yes.
Rob is like, I guess I've been volunteered, and you have.
Oh no, I mean she's out for 2 weeks, and that's 2 weeks when I have a 3-day trial, contested motions hearing, and then a 2-day trial the following week. I'm like, oh, this is good. This is gonna be we're gonna. It's all okay. We're gonna be fine. We'll be okay.
You're like, it's all good.
Yeah. We'll live. I think we'll live. I hope we'll live. So yeah, and then there was the other thing that I wanted to share before we got rolling into any of the topics was someone sent me this. This is a cross-stitched. This is my new favorite thing. Don't hate, litigate. Probably one of the coolest things that someone has made. Because, like I say, go make something that'll make you feel better. And
I mean,
your making of this thing made me feel a lot better.
You can do both. That is allowed.
You can hate and litigate. I mean, you can. And then kiddos.
I think your opposing counsel is indicating that.
Yeah, that's true. One of my channel mods made an equivalence that I didn't realize was that someone called me Iron Man, or they called me Iron Man, and they called Mischief Pepper Potts. And I was so stunned by that. And of course, on my birthday, the kiddos got me this little driver cover for that's Iron Man.
Oh, that is cool.
Yeah, it was pretty neat.
I immediately just went like, noting the leather on that. I'm like,
My shop is going to be out of commission.
I have some thoughts I should.
Trace Fagan, you ever told us if your Girl Scout won top sales? So Mama G's daughter is who we raised the Girl Scout cookies for, and she destroyed all competition. Y'all raised, I think, sold almost 1,000 bought 1,000 boxes of Girl Scout cookies. So yes, she definitely won top sales and all of that.
So get wrecked other small cute children.
Yes. So chat, you wrecked small cute child in the Stroke Awards, and you wrecked other small cute children in the Girl Scout troop. So chat is 2 for 2 on wrecking small cute children.
That just makes that just sounds so wrong.
It really does. It's terrible. Shouldn't be the case, but it is.
Chat, we're all awful people, and that's okay.
You shall all be punished with more commentary on legal stuff. That's the punishment.
This kind of sounds like a punishment ice cream situation.
Yes, I love punishment ice cream. It's the best form. Yellow Pill says, Runkle, what's your P.O. box? You need a silent keyboard on behalf of the Neurospicy chat.
This is supposed to be a silent keyboard, believe it or not.
He just aggressively types it.
No, it's just that nothing is actually that silent when you're, when you're nearby it.
The mics pick up everything. You guys, the mics picked up Leo farting when he was on stream the other day. So, anyways, okay. So first topic of the evening, and I forgot I didn't do a single swoop during the entire birthday stream, so we got to play catch up on the swoops. First topic of the evening is actually a lighthearted thing, kind of, until let's see. There was an article that one of my mods found and shared with me. So this comes from The Guardian. The source is what it is, but the article itself is kind of interesting. North Carolina child's monster in the closet was, in fact, 50,000 bees in the wall. Yeah. So family discovers terrifying gigantic bee colony in the wall of a home with blood-like honey oozing down the wall and 20,000 in damage. Bees apparently do a lot of damage.
Also, I just want to say, like, the blood-like honey element, like, nobody needed to hear that today.
No. The concerns, this is the best part. So a toddler tells her mom there's monsters in the closet. But in fact, they were just, 50,000 bees. I would consider that a monster. Mother of 3 children under 4 years old, well, that's tough as it is, was met with a terrifying surprise after she and her husband investigated why a handful of bees had flown into the attic of the couple's North Carolina home. After a visit by a pest control company and multiple beekeepers, a thermal camera So they used a thermal imaging camera to finally reveal that their bees had gone to a massive hive they had built inside the wall of their daughter's room, where the girl was convinced she heard a monster or some kind lurking.
I
The
mean, she
mom
was
goes,
right.
hey, she kind of was. The mom goes, at first I thought it was a body. Well, that's something. It's like, what was that? He thinks it's a hive. Ugh. Yeah.
Now, 50,000 bees doesn't actually seem like that many. How many bees is that in like buckets of bees?
I don't know. How many bees could one fit into a bucket?
I don't know. That's kind of why I'm asking. Like, how many bees is this in terms of like mass of bees?
Is there a photo? I don't know if there's a photo or not. Stupid Guardian politics stuff. Let's see. This is the best part. This is one of the best parts. So the 8 months is when the swarm of honeybees has been building the hive inside the wall. The beekeeper, quote, didn't even have his bee gear on yet, but he took a hammer. And then, so I'm going to go ahead and not just say the quote verbatim. He took a hammer, thought in his head, hold my beer, and then knocked the hammer into the wall. And the bees just came swarming out like a horror movie. Yeah, that's what bees would do. Why are you throwing a hammer into the wall when you hear the buzzing?
Because apparently he's got a beer.
There was a stream of bees, and the wall where he hit was oozing honey. But it looked like blood because it was really, really dark running down my daughter's pink walls. Ah! No. No.
Rob, you're just saying the because it's like something out of a horror movie.
Yeah, that is literally something out of a horror movie.
I mean, somebody right now should probably be writing this horror movie.
Oh, wait, this is actually on TikTok. She actually videoed it. Let me see if there's any music behind it.
Of course there's music behind it. It's TikTok.
I know, but if I mute the music, hopefully they won't. Let's see if I can share this. I want to see if they actually have the video of the actual. Oh, there's the wall. There's the wall. There's the wall. There's the honeycomb. Let me see. Nope. So this is a multi-day extraction.
Extraction Venza
of the bees. Bees. I don't like bees. I can get along with a lot of things, man. I don't rock with bees. I not okay.
I mean, bees are just nice.
I got stung by like a whole nest of yellow jackets in South Carolina when I was a little kid. My dad
That probably was a you problem, though.
I don't know if it was a me problem. Oh, there is a video. Hang on. It's not a scary video.
Like, just so long as you don't do anything wrong, bees won't typically bother you. However, note that they consider things that you're doing wrong to include things like, well, at least when you're talking about yellow jackets, that includes things like, breathing and existing. So, yeah. I mean,
that was one of my first memories of like my dad, like hero moments, was he walked over, picked me up when I was covered in yellow jackets, like picked me up and took me into the bathroom and then just turned the shower on to try and use the water to get all the bees off me. So that's like the first hero moment, but that's the thermal image of the bees as the bees. So
see, now if you were prepared, you could have had the not the bees clip all queued up.
Yeah, no, I'll rock with bees. So
have you not seen that clip?
No. What clip is not the bees?
Nick Cage in something awful.
How dare you? Nick Cage he's a masterful actor.
Sure, but that doesn't mean that every movie he's been in has been top quality.
Don't you dare. If you go after Con Air And Nick
Con Air
Cage
wasn't where I was
is Steve
going.
Buscemi. Nick
Con Air
Cage
wasn't where I was
is
going.
Steve Buscemi.
The movie is Wicker Man.
I don't know if I've seen that one yet.
Let's just say that on your priority list, it should be low.
Yeah. Okay, that's fair enough. But I've also seen the Sorcerer's Apprentice was terrible. You know what? There are certain times when a bad movie is just needed. Like what was the other one? Ghost Rider he did. Oh gosh, it was so terrible.
Yeah, and I mean,
bad movies.
There's bad movies that are fun to watch, and there's bad movies that are just bad. Did you ever see the movie Stealth?
Oh yeah. Oh no, that one's so bad. That's with Jessica Biel. Who else is in that? Jamie Foxx is in it, isn't he?
I blocked lots of it out of my memory.
Oh, it's so terrible.
It is one of the worst things I've ever seen, and it is pretty much a crime against like man and God. Not or and.
Yeah.
So
I guess. Ryan Man at YYC says, Rob, check DMs. I did. Let's see. Oh no. I would appreciate, I appreciate this because that's your sense of humor. Let me see if I can't check DMs. There we go. Look, golf ball float. But then there was this gold. This gold is in there. That meme is probably one of my new favorites. Per my last email. Thank you. I needed that. That's awesome. John Comment says, thank you. The mics picked up Judge Glanville farting during the YSL trial. Nick has the video. Oh no. No.
That's another reason to keep the mic muted until you want to talk.
Volkus says, are we supposed to be? You leave that. Yeah, you are. I think so. Braxton Heaps, 5-gallon bucket holds about 100,000 bees. All right, so it's just a half of 5-gallon bucket, 2.5-gallon bucket. That's a lot of bees. I don't want that many bees. I'm done with the bees. Even though they're great, I know that we're supposed to save them. Lynn Britton, bees in the wall, nightmare fuel. Indeed. Only thing worse would be spiders, which I just put in people's mind. I'm sorry. Mispronounced name, Yellow Jackets are a-holes. Bees are cuddly friends. Yellow Jackets are a-holes. Can attest. Tracy Bacon, hey, Ghost Rider was Sam Elliott. It has Sam Elliott in it. I'm not disparaging. I told you it's a terrible movie. It's just.
Oh, the thing is Sam Elliott is great in it. The rest of the movie is the problem.
Yeah, it's just sometimes you have bad movies. K-Ducks 007, Google says 85,714 bees equals the volume of a human body. It's a human bee. Ugh. Smurf Anna says scary bee movie. Nope. Candyman. That's one reason. Nope. I'm not a big fan of the scary movie. I like the dumb movie. So. Kristen M96 says there's a caregiver award in regard to the Stroke Awards, Stroke Hero Awards. I feel like a group of lawyers could write some kick-ass nominations for Mrs. Hogue, just saying. If we had known, we could have nominated her well in advance. But I think that she gets the Stroke Hero Award in my book. Absolutely.
100%.
All right. So what do you want to talk about? You want to talk about Sam Bankman-Not-So-Fried, Brian Kohberger, or Karen Reed? I have a preference, but I don't know.
All of those are good. All of those are good, although I am late. I am not up to date on like the latest in Kohberger, so I don't know what the latest and greatest is there.
We'll save Kohberger for last. Let's do SBF first. SBF is pretty easy. So Sam Bankman-Not-So-Fried remains not-so-fried. But interesting development that happened, I believe it was last week. Let me see. Yeah, the filing itself was April 19th. But as of the date of the filing, we didn't have, or as of the date that it was being published, we didn't have some of the stipulation itself. So you guys remember Sam Bankman-Fried was the crypto king, not so much anymore, of FTX. He founded FTX, which is a crypto exchange. Now that I said the word crypto, there's going to be trolls in the comments at the end of the video, which it just happens. Sam Bankman-Fried, convicted, is now serving 25 years. Yes. Stole over $11 billion from FTX, testified in his own defense.
I believe he said that he was only borrowing that money.
No, he said customers could be made whole, and he was really angry. Not that the conduct he did. He was angry at the fact that he got charged with it. Anyways, total class act human. And you guys might remember at the beginning of the story, there was a whole lot of the influencers that FTX had gone out and hired to promote the brand, including Tom Brady with his flamethrower, all of the above. Actually, where is that?
To be fair, the flamethrower was pretty boss.
Let me see. Tom Brady FTX flamethrower.
Guys, Christmas is coming up, and I do accept flamethrowers.
The Canadian government does not want to hear you say that. So for those of you who are curious, this is the Tom Brady commercial.
So Rob right now is hitting all the selling points because he's mentioning that it's going to make the Canadian government angry.
Yeah, true. Swoop. I almost forgot the swoop. So this is one of those little influencer ads with Tom Brady, who's been sued by a lot of people because of the loss of the FTX stuff. Totally promoting FTX. Don't worry about it at all. We can totally trust it. Look at the crypto. Yeah, man.
Oh, God. That said, that flamethrower is actually pretty lame. We need a better flamethrower.
Stop that. So you guys remember that all those influencers went out and they were promoting FTX left, right, and center. Everyone was super happy about it because, what could possibly go wrong with promoting a crypto exchange? Nothing. Gisele Bündchen was in there as well before their divorce and separation. So, maybe it's part of his life he doesn't want to relive. Anyways, that lawsuit ended up happening. Adam Moskowitz is the filer of that lawsuit. Why can I make this go away? No, make that go away. Adam Moskowitz filed the lawsuit on behalf of a class action suing all these influencers saying, give me money because I invested with FTX based on the influencer conduct. And I lost it all. Sam Bankman-Fried, who wanted to cooperate with the government so very much during the bankruptcy case that he was kind of barging into John J. Ray, who was the trustee over the estate, saying, I can find all the money. Help me find all the money. We can get it all back. Meanwhile, prosecution's ongoing. And, John Ray is unwinding this crypto exchange that was run on a database of QuickBooks, Slack messages, text messages, and emojis that were confirming transactions of millions of dollars. So what did Sam Bankman-Fried do after he got convicted? Well, interestingly enough, he agrees now to help the FTX investors go after the very celebrity promoters that he cultivated.
Are they paying him, is he getting precisely 40 silver coins for this one?
No, he's not getting anything. It's pretty great. So Sam Bankman-Fried has inked a settlement agreement with a group of FTX customers who have agreed to drop their class action lawsuit against him in exchange for his help going after the celebrity promoters of the collapsed exchange.
Because they're the ones who have money now.
Because all of his has been turned over to the government. So he's like, you know what? Yeah,
I did tell them. I can pay you in mackerel. And
they totally should have known.
And ramen.
Where was it? I don't think Rob's paying attention. I don't think Rob's paying attention to chat tonight. I am. It's just difficult to read and do 4 things at one time. My ADHD is not fully ADHDing right now. The X at the bottom. Yeah, all the chat. Just took me a minute. Where's Leo? Leo is at Mischief's house. Let's see. Catching up. The agreement filed in Miami court on Friday has not yet been approved by a judge. If approved, the settlement would release Bankman-Fried from both current and future civil liability tied to the collapse of FTX. Well, that's interesting. Bankman-Fried's end of the bargain will see him providing the plaintiff's attorneys with information, including both testimony and documents in his possession,
Couldn't they just subpoena him for this?
I don't know. I think they kind of just knew, like, hey, I know we can't get anything out of you, but you want to come along and I'll just make this lawsuit go away. And Bankman-Fried's like, sure, why not?
Yeah, I mean, I suppose it could be easier, but I'd still want him on the hook.
Yeah. Ian, would you mind taking over reading for a second? Left off.
Are we at the top? Including both testimony and documents in his possession to aid in victim recovery and assist their litigation efforts against a host of celebrity promoters and venture capital firms who endorsed FTX. Interestingly, I think that includes Larry David, whose role in the commercial is to say this sucks. He also agreed to provide the attorneys with financial information and documents, including a total of his remaining personal assets and his firm's 2021 investment in AI startup Anthropic, whichever. The pending settlement agreement comes shortly after Bankman-Fried was convicted of fraud and sentenced to 25 years in prison for his role in FTX's implosion. Bankman-Fried has appealed his sentence and his conviction. I hope he is successful in getting... Whoop, I messed with that in a way I didn't mean to, but oh well. I hope he's successful in getting his sentence overturned and increased. So I messed with the layout somehow here. Bankman-Fried's one-time friends, colleagues, and co-defendants Carolyn Ellison, Nishad Singh, and Gary Wang, as well as FTX lawyer Dan Friedberg, have made similar settlement agreements with the plaintiff's attorneys. Several of the smaller celebrity promoters, including finance YouTubers Andre Geek, Graham Stephen, Jaspreet Singh, Tom Nash, Brian Jung, and Jeremy Lefevre, have also settled, contributing to a common fund of $1.4 million to fund the lawsuit, according to court documents. Jacksonville Jaguars quarterback Trevor Lawrence, who was paid $500,000 in 2022 to endorse FTX subsidiary Blockfolio, also settled with the plaintiffs last year. But most of the big-name promoters of FTX, like athletes Tom Brady, Steph Curry, Shaquille O'Neal, Naomi Osaka, and Shohei Ohtani, and supermodel Gisele Bundchen, are fighting the lawsuit, as are over a dozen domestic and international venture capital firms. And you know who's not on that list? Taylor Swift.
I know, because she turned down reportedly $100 million.
Yeah, and that was probably one of the most sound financial decisions of her existence, which has been marked by fairly sound financial decisions, given that she is a hojillionaire and I am like a 100-aire. So I feel like she makes better financial moves than I do.
I'm not being rude here, but I don't know if we have the same talent.
I am pretty sure we don't.
Like I said, wasn't trying to be rude. What was the one that he filed against?
We have similar abilities to move people into, like, with respect to an auditorium. Just she can move them into an auditorium, and then if I got up to sing, I would be able to move them out right afterwards.
But wait, what was the lawsuit? What was the name of the lawsuit against the BitBoy Bros or the Crypto Bros?
Oh, BitBoy Crypto?
Yeah, but the name of the lawsuit, it was start with a G. It was Garish? No. Yeah.
I can't remember.
Hang on. I gotta see, because if there's a cooperation agreement in there, I want to pull it up too. Was it investors? So let's see if we can find, just by searching BitBoy Crypto, who's no longer BitBoy Crypto. He's now something else. He just did a whole mess of things. He was just not. Yeah. Where was this? The lawsuit. So Moskowitz filed this one too. And BitBoy Crypto was the one that was calling Moskowitz's office every 2 minutes, screaming at him. Kevin O'Leary, the SEC, the official statement. Where was this lawsuit? I will find this. I need to know this. My ADHD will not allow me to not know this before moving on. Come on. Chat's probably going to have it. Let's see. Crypto hide behind language. Class action suit. For Ellison lawsuit alleges. Let me see if I can't see. If I can find it by searching for his name. Ben Armstrong. And I'll throw Moskowitz in just for shits and giggles if I can find it. Garish versus Paffrath. I knew it started with a G. Where did this thing go? Tell me there's a cooperation agreement. Please tell me there's a cooperation agreement.
I don't know if there's a cooperation agreement.
No, they stayed the case. Retain jurisdiction to put it back on the active docket. Discovery issues. Where did this go? I'll look that up a different day. What? Scheduling order. Oh, it transferred. But where did it transfer to?
I don't know.
Internal monologue. This is a rabbit hole. Why am I in this rabbit hole?
Because that is what we do here.
That's the Sizemore v. Zhao. Did that what it get? Is that what it got renamed?
Rob is having a moment, folks.
No, I'm not. Yes, I am. I found it. I found it. Motion withdraw, unopposed, yada, yada, certificate of understanding, RE electronic filing, attorney appearances by the parties, waiver of service, certificates of miscellaneous things, different attorney appearances, withdrawals of appearances, very boring stuff, nothing exciting, waivers of service. Everyone kind of saying, sure, why not? We'll go ahead and dismiss the MLB. Yeah, MLB got sued in this one. Approval of settlements. They did. He's cooperating in this one too.
Huh.
Yeah. Okay.
Good for him.
You know what? Why not? So, litigation settlement overview, all of this other stuff. Now, let's get to the meat of the issue, which was his cooperation. Criminal proceedings. We know how that ended at 25 years. Conviction for Sam Bankman-Fried. His testimony that was the worst testimony of all time. His sentencing testimony and statement, which was probably worse than that. Claims the benefits of the settlement by the class. The defendant's position. They deny all claims. Yes, they do. Now it's stipulated and agreed by and between the class representatives and the defendant, by and through their respective counsel, that subject to the approval of district court pursuant to the rule, the litigation shall be finally, fully, and forever resolved regarding this defendant, Mr. Bankman-Fried. Now, what does he have to do specifically? Because if it says he has to testify honestly, I think he might have a problem with that.
It's like, and the settlement has blown up.
Yeah, he doesn't have a good track record. Plus, if I'm opposing counsel and he's testifying against my client, sir, weren't you found to have lied 5 times under oath, like by the judge that sentenced you to 25 years for fraud?
And he's like, that's only the number of times they caught me. Whoops.
Yeah, he's probably going like, I just want to make sure I get all the customer money back.
And it's like, and 6. Actually, that's not true. He does want to get all the customer money back. He just doesn't want to get it back to the customers.
All right, the obligation. So here's in full and final settlement. The defendant will provide the following benefits to the settlement class. The defendant shall reasonably
each of them gets to kick him in the junk.
That would be a lot of people. If we're talking about a full class, that's a lot of kicks to the nuts.
And all of them are like
warranted,
justified.
Yeah. So he's going to aid in victim recovery to the extent that he's able to do so under the circumstances. That's a whole lot of caveats.
Well, to be fair, he is in jail, so that does impede recovery.
Yeah. The information shall take the form of defendant's testimony, documents in his possession, custody, and control to the extent defendant has possession, custody, and control, yada, yada. He will use his best efforts to identify information, will not object to plaintiff's request for production of information by the U.S. attorney. While class counsel is aware that defendant is currently incarcerated for the foreseeable future and has substantial restrictions on what he's permitted to do, yeah, properly. Oh, gosh. And when under the circumstances, the defendant shall make his reasonable efforts to cooperate as follows. To the extent he's not already done so, he's going to voluntarily produce without service of subpoena all non-privileged communications or documents he produced to the U.S. attorney. Okay, that's fine. No problem there. To the extent he has possession, custody, and control of information. Minutes. Yeah, just attorneys send this over. Produced, he'll endeavor to identify information. Okay, so he's got to identify docs and information. To the extent he's not already done so, he's voluntarily produced without service of a subpoena, either A, a financial statement demonstrating all assets that he currently holds, accompanied by a sworn, which is right now like none.
He's going to have to indicate like how many packets of ramen he got out of the commissary.
I have 2 toothpastes.
I think two toothpaste is actually an institutional violation. So I think you're only allowed 1 toothpaste.
That's probably true. Accompanied by a sworn affidavit for what good that's worth, or a declaration listing all of the defendant's financial assets, again, for what that's worth.
I mean, to be fair, there might be a lot of value to his sworn affidavit, especially if they can have it printed in 2-ply. With the width of like 4.5 inches and a length that's indeterminate. That becomes useful.
He's got to produce information relating to his investment by him in Anthropic PBC. Okay, so they're looking to claw some money back. Which they filed that, so they just tipped the government off like, hey, there might be assets here. So the government's like, we're gonna get there first. All documents possession relating to funds, assets, prospectuses, subscription agreements, capitalization tables, basically all the money. Tell me he's got to give communications. I want the communications. Parent subsidiary entities, all the company stuff, the agents, directors. Look at all of these entities. This dude running shell game within shell game. Look at this. Upon request, he's got to produce truthful declarations or affidavits with respect to any non-privileged information regarding the following people or entities and their parents, subsidiaries, affiliates, officers, directors, employees, agents, and other representatives. This is a ton. FTX Group, Sino, K5, Paradigm,
now,
Ribbit.
They mean corporate parents, not like literally like his parents who are at Stanford, which seems to be the crimiest university in town.
Oh, Sullivan Cromwell, his attorneys, David Ortiz, the baseball player, Shaquille O'Neal, the Golden State Warriors, the entire team, Larry David, there's your boy, Gisele Bundchen, Tom Brady.
I think it's hilarious that he's getting sued for this one because his role in the commercial is literally to be,
this sucks.
Yeah, this looks crappy. Don't invest in it. And it's like, don't be like this. Don't be like this guy. You should invest in it. It's like, I get that he lends his name to promoting it, but at the same time, his role is, it's like he's the only one in those things who actually gives you sound fight. If you listen to Larry David in the ads,
you would not be.
You still have your money right now.
Yeah. Formula One racing, Mercedes-Benz, Riot Games, Furia Esports. It's a lot.
I used to work at Riot Games.
All the SEC documents. So Sam Bankman-Fried has gone turncoat. He is now snitching.
To be fair, late, though. Well, I suspect he tried to snitch earlier because I feel like being a snitch is probably in his blood.
Oh.
It's just another kind of weasel that, like, he's every sort of weasel rolled together into one.
I mean, this might seem harsh to some people who haven't seen his cover SBF before. This is the dude that took Carolyn Ellison's like private diary entries that he had somehow access to and leaked them to the New York Times so they could basically shame her. Like that, like I have no problem.
Yeah, the guy
just
is an absolute
bashing this.
weasel who has basically thrown everyone he's ever met under the bus to the greatest extent he is able to do so. So the news that he is now snitching on more people is like, oh, it must mean he found more people because there was no real limit to his snitchery before. So,
The
yeah.
dude's entire mentality is it wasn't me. That's it. Like he is that Shaggy song. Like it wasn't me, but they caught me in the counter. No, it wasn't me. But they caught me in my condo. It wasn't me. Caught me rolling on my yacht. It wasn't me. I took the money from right under them. It wasn't me. Oh, gosh.
I mean, the guy, it's not just it wasn't me. It's like, it wasn't me. Blame Julia in every circumstance, you know, he possibly can. So, and they're not even doing anything to him with rats yet. I mean, hey, you know, hey, government.
Citrine, how dare you insult Alex Murdaugh that way? Alec Murdaugh that way. SBF and testifying honestly equals Alec Murdaugh versus the polygraph. They might give each other a run for the money. I don't know. Wouldn't that be an interesting dialogue between the two of those individuals?
Oh, that would be cool if they could end up sharing a cell.
No, it wouldn't. That's like every human's worst nightmare. You might have one try and teach the other. Oh my gosh, the educational lessons on how to crime worse.
And then you just weld it shut.
Is this a safe that you drop to the bottom of a river? Is that what you're talking about?
I mean, it doesn't have to be a river. Just about any body of water will suffice.
Just a transatlantic crossing.
Yeah.
Nah, I would never wish
actual harm. It doesn't have to be a river.
This is it's right now. It's right now. It's joking because one of the hottest takes I've ever seen is people in the aftermath of the SBF conviction and his 25-year sentence. People saying he was punished too harshly for his actions. No.
Nah, I mean, he could get another 25 years, and I would think he's still doing all right.
Yeah. So we're fine with how he was sentenced. If anything, we think it was under sentencing. So, oh my God, the people that were jumping in after that, like the people that covered the trial, like for 2 seconds, not actually knowing the story, but he's getting, this is so serious for something that's just a financial transaction. Nah, dude, 8 billion from one set of customers and then 3 other billion that's unaccounted for is not just. And when you're talking about teacher pension funds, no. And people that were self-unaliving in the aftermath of that collapse.
Yes, he is invited to go to the land of F himself. And yeah, that is kind of my feelings on this.
Okay. Now we are to I guess the soup du jour, the topic of the day. Let me see if I can't get caught up in so many questions that we might have. More.
Oh, I like the idea. Somebody in the chat had a great idea for who his cellmate should be. It's the 50,000 bees. Sorry, I was just thinking that through, visualizing it. Casey Cat, thank you for the gifted memberships, much appreciated. Ryan Met YYC gifting memberships. There's a lot of gifted memberships tonight, guys. Like the membership fairies are raining down. You guys are amazing, growing the channel the way you do. Roro, thank you for the gifted memberships. Elise, Charlene, when I was 5, I was stung by 50 bees, one up my nose. Oh, that's a bad place for bees. Don't insert bees in the nose holes. Or really any other hole. There are no B approved holes.
No, that's no.
Also, this is a terrible time to have an imagination, and I feel bad for any of you who do.
I don't like you at all. Fiona W, thank you for the gifted memberships. George, the cat, the bee thing happened to me. I'm allergic and paralyzed. Oh my gosh. Became so stressed. I had a seizure. No one was home. Oh my God. About 6 by 4 foot space, 60 pounds, Africanized honeybees, 6,000 to fix it. Holy smokes. I hope you're one. I don't know if it's George the cat, like the actual cat, or George the cat's owner that was stung by the bees. In either event, I'm really sorry. That's a brutal. Oh, Molly Biddy. Hello from Kilkenny, Ireland. Working part-time. Funds are low. Don't spend money on Super Chat, but wanted to show support. Thanks for making all this legal stuff make sense. I try. Now we get to the Reed case. I'm going to have more difficulty making some of it make sense because right now we're in the world of I get confused. And I think I'm not alone in that regard because right now we're making progress towards a direction I don't know. Bop it. Thank you. Donation for the flame-throwing dog robot.
Have you seen this?
I have.
I want one.
It is. I know you do. I think that your pups, like Zora and Potter, would get very jealous, except for the fact that it doesn't eat food, just gasoline.
I might take it for walks more often than I take Zora and Potter for walks.
See, now my imagination went to where you would take that dog for walks. And I was like, nope, don't say that out loud. That'll get you in trouble.
My lawyer has advised me not to confirm or deny any locations I might or might not take the flamethrowing dog.
That's why I stopped talking. Yeah. Thank you, Boppet. Much appreciated. Ian Paler sent a DM linking a Steve Leto video about a UK solicitor that filed the wrong divorce. And the courts to ensure drama.
Or to ensuing drama.
What?
I'm guessing he just like divorced a random couple, or
that's terrible.
Hilarious.
I mean, I don't know. Hang on. Law firm accidentally gets wrong couple divorced. Oh my God. It's a whole video. I have to watch that separately. Oh no. Okay. I'll have to watch. That might be a offshoot for like next week. I have to watch that video, get caught up on that. And I'll tell you about the law firm that divorced the wrong couple. Wow. Wow. Okay. The world wonders. Ian has an uncanny ability to kill any regrets I have about having partial aphantasia. Yep. Remind me what aphantasia is.
Inability to picture things in your head. Like, for instance, bees.
How'd you know that
where bees might go?
So it's a vocab word, man. How'd you know that? You use that in filing?
No, I just know words. Words are fun.
Sandy, wishing my husband a happy belated birthday. Happy belated birthday to Sandy's husband. Remarkable dude. Got to spend some time with him in St. Augustine. A lot of fun. Casey Cat, I guess here's to us wrecking small children. I guess that's where we are. Now, here's one that deserves a glass raised. Scott, my father's funeral was today. Could you please raise a glass? I will.
I feel like I need to pour something a little better.
Why don't you do that? You pour something. I'll save this, and I'll bring that
because I feel like pickled bean canned Caesar is not an appropriate drink for that.
Not appropriate for that type of toast.
So I'll be right back.
Yeah, you do that. I'm going to pull up a couple more, and we'll pull that up when Ian gets back with something proper. Casey Cat Swoop. I didn't forget. I only delayed the remembering. Stephanie sending hearts a Hogue and all those in chat tonight. Thank you, Stephanie. Very much appreciated. Bills, Momzilla, Julius and knitting. What is a Bojalias? B-E-A-U, Julius. What is that? Ooh, French wine. Oh. Yeah, I could do that. All right. Medium bodied red, light on tannins, bright, juicy freshness. Fair. Solid. Very solid. Daily dysfunction. What, if any, Elaine flashbacks are you having? All of them. Every single one of them. Cannot stop. It is driving me nuts. That's why Elaine's on the thumbnail. Alicia Arlene Fine Arts. Thank you. Watching 2 lives. Friday Frenzy. Emily Illustrators. Fun. I don't know how you guys watch the 2 streams at once, but I appreciate being here. Yayko. Ian, can you read Rob? Oh, I'll have him do that when he comes back. I have been following a bit of that. It's pretty nuts. Tough Cookie, thank you for the gifted memberships. Jen K in Disney to celebrate the Star Wars Replay Crew rewatch. We love the Replay Crew. If you guys aren't a Replay Crew, good point in the show to remind you. YouTube is doing the YouTubey things where they're unsubscribing people again. They say they don't do that, but they are. So if you wouldn't mind, if you're listening and watching the stream, please hit the little subscribe button. It's right there at the bottom. You can catch all the future streams that go on. And if you wouldn't mind hitting the like button, again, it's just right at the bottom of the screen. It's like 2 seconds. Just hit the like button. Just like, because what it does is it says, YouTube says, I like this stream, or people like this stream. So we're going to send more people to see what these lawyers are talking about, or in some cases to hear and be traumatized by Ian's hypotheticals. So like button, just hit that. Really easy. As 01, happy Friday, Rob, Ian, and Sparkle Farts. Happy day indeed. Highlands, New Jersey with a Negroni from Thilo. Enjoy the beverage, my friend. Debbie Blair, enjoyed every minute. Thanks, Rob, mods, and chat. Yeah, last week was a lot of fun. It's been a lot of fun. Judy M, 5 months of fantastic fun. Thanks, Rob. Thanks for being here for the 5 months, and thanks for being a member. Killer Stink Wine in Nebraska, safe from tornadoes for the day. There's been a lot of tornadoes. I hope that all of you and your families are well, safe, and kept safe during all of these crazy tornadoes and storms we've got in the Midwest and in the breadbasket. Linda, Santiago, shots of whiskey with a beer chaser. Solid beverage of choice. I always like a pickleback, though. It's one of my favorites to whiskey. Michelle
Really?
Lee's hot tub.
That surprises me because
picklebacks
are good.
Yeah. It
I did not
any of the
picture
harshness.
I did not picture you liking a pickleback, but we will have to in Nashville. There's going to have to be some picklebacking.
Oh, that sounds
that does sound wrong.
Maybe don't say it that way. Let's find a different way to say that, because I don't like the way that made me think. No.
That is fair, but picklebacks are delicious, and yeah.
Michelle Lee's hot tubbing in Michigan, drinking tea, safe and responsible. All right, you got a beverage?
I have an old fashioned made with some blood orange bitters, and it took me a little while longer to make it because there's a lovely woman who comes in to do some cleaning every once in a while, which is one of the sort of ways I keep my attention deficit from being too much of a burden on Mrs. Runkle. But Mrs. Runkle was like, hey, can you help organize our kitchen a bit? And she did an amazing job. Everything is neatly organized, and I have no idea where any of it is. So it took me a while to find for this.
It's cleaned too well. That's part of the ADHD brain too. Don't move stuff. It might not seem like it's in any particular place, but I remember where it is. If you move it, I can't remember where it is.
Yeah, so it's like there's sugar somewhere. It's neatly organized, and I just I had no idea where, so it took me a while to find that. So yeah, but yes, I finally did make an old fashioned.
Okay, well, Scott, my father's funeral was today, so you please raise a glass. I will absolutely do that. Scott, to your father, man who probably taught you some of the best lessons you'll ever learn, even though you only realize those lessons later in life. Man that probably was your hero and was probably the biggest person in the room that you ever remember. May his memory live on. And may you continue to see and talk to him throughout your days and in all times of trouble. So cheers to your father and all he was to you and your family. It's coming up on that time of year too. It's going to be a 5-year anniversary of my dad's passing. So,
ooh, that's
it's weird. Just weird. That's all. Yako would like you to read me in on something that I have some knowledge of. The Owens versus Eckerd cases. The Owens versus Eckerd case.
So this one is kind of crazy. The basic issue.
Pause. Side note: Megan Fox and Legal Vices are covering this almost like beginning to end, covering all the pleadings, like everything.
Yeah, I'm piking at it. Like I just don't have time because there's so many things I'm covering, but they're focused on that one, so check them out. But basically, so this woman claims that she got impregnated after a hookup with, with a guy, and basically
it actually bears saying the level of hookup. The level of hookup was not
the level of hookup was
type that would
such that
babies.
Yeah, all of the insertion was sort of north of the shoulders. We'll put it that way.
It's a safe way of putting it, but
safe, but also weird. So, which is kind of my brand, I guess. So,
wait, safe way of putting it. That was the wrong way to say that too. Damn it!
Well, you did that one to yourself.
I did.
So, anyway, she initially claims that like something must have dripped.
Oh, yep. I understand. Yeah.
Like
claims that there was by some fashion, something got in that area, and that the limited time that it was in that area after being exposed to the air resulted in her conceiving not one child, but 2 children, twins.
Initially, she's claiming it's like one hell of a 3-pointer. So, yeah, later on, she will claim that it was not that, and that it was instead, some sort of forced altercation. So, but her story keeps changing. Anyway, she says she's pregnant. She's provided very poor information to suggest that she was ever pregnant. The timeline on it keeps so she says she has a miscarriage at like a particular point, but then for some reason her belly keeps growing after that. Everything about it is weird. So
she admitted to doctoring images of sonograms. She used a sonogram that was someone else's sonogram.
Yeah.
The medical establishments she went to have no record of her being there or appearing there.
Yeah, it's bizarre.
Like there are cases where I get nervous talking about like these kind of allegations and really looking at them and trying to give people the benefit of the doubt in every respect. But this case is one where it's absolutely physically impossible for all of her statements to line up and be the truth. It's just not physically possible.
It's not physically possible for her statements to be like in the ballpark of truth or in the ballpark of like reasonable errors, right?
They don't share a zip code. Truth and the statements, like they are just not there.
They don't share like a genetic, a single scrap of DNA. And to put that into perspective, we share like 60% of our DNA with like a banana. So that tells you something.
The case is completely wild. Absolutely. I cannot wrap my head around it. And I would recommend the coverage by either Ian, who's covering it, Legal Vices.
I'm covering it a little bit. I've covered like one of the things. I just have so many things to cover.
There's a lot. It's a lot going on. So, okay. I see a bunch of the member chats. I'll have to catch up to those after the next topic, but I really have to get to the next topic. Absolutely. John Common north of the shoulders was she standing on? No, it was just not. No, that's not how that worked. Nope. So we are going to swoop to coverage of the Karen Reed trial and updates from the end of week 1 and day 9,565,000 I think it's honestly day 4. But is it 4? Yeah, it's day 4. It started on Tuesday. Yeah, day 4. So let's swoop to that. We'll do double swoop. Okay, the case of Massachusetts versus Karen Reed. Everything, I mean, everything that I don't want to see. I know the one popped into your recap stream the other night, and I asked them, and Emily asked them really emphatically to stop focusing on the fan. Because this is the image when Court TV pans away so the jury can enter and exit. This is how they leave you. So this is day 3. So day 3, they're focusing on a fan, and yes, the fan is the clock. It's the thing on the wall that they focus on when the jury's entering or leaving, and it's just the screen holder. So Ian, you remember on day 3 after you did your recap, and we were in the chat, and Emily and I were saying, hey, Court TV, it'd be great if you stopped focusing on this moving fan and driving us all insane.
And then they didn't listen?
Oh, no, they did. They did.
Did they stop? Oh, man.
No. They're trolling us. Here is how they're trolling us. They focused on a different fan.
Those bastards.
I thought that this fan was the only fan.
Yes, Rob.
I know. I thought this fan was the only fan, but it turns out that these fans are the only fans. So,
Rob.
So Court TV, you know what? Good on you. That was solid move. Solid move. And it took me a second because when I saw the video today, I was going, that wasn't what I saw yesterday. Yes, God. These fans are the only fans. So Court TV has focused on the only fans. It was funny when it was the only fan, but now it is officially Court TV focusing on the only fans. So Court TV likes OnlyFans. Sorry. Also not sorry. So, yeah. So this is the pause screen, or the screen that happens when Court TV is deciding whether or not to focus on the case. The case itself has been remarkably well. How would you describe the start to the case, the opening statements?
Let's see. From the defense, masterful. From the prosecution, full of something else.
Just seems like they don't. Well, we've talked about it a little bit. Ian's done recaps of it. Please check Ian's channel out for the recaps. He's trying to put those out when he can, even though he is, again, full-time practicing lawyer.
There's going to be another one tomorrow, I'm thinking, to cover the last couple of days. So, yeah.
Yeah. We're not going to go too much into it, but there were some parts of it that just...
Also, I feel bad for all the people in the chat who are like, my cat/dog heard the bag crinkle and is now angry at me for not having any treats.
Yeah, tons of people are pissed at you right now, and animals are very upset at the lack of treats. So from the original, so right now we have gone through a bunch of paramedics, firefighters, and individuals that were first responders. So for those of you who are not privy to the facts, well,
I have learned so much about what it takes to be a paramedic and so little about what the actual case is about for the prosecution.
Here's what we know so far. Karen Reed discovers the body of her boyfriend, John O'Keefe, the morning after the two of them had a fight and dispute and involved drinking and going to a bar, or desire to go to a bar. Karen Reed discovers John O'Keefe unresponsive in the snow. We did prove it was snowing via 6 witnesses that testified to the snow and how much it was snowing.
See, I have credibility problems with those witnesses because they say it's like a a legendary blizzard and like
You're
this
Canadian.
huge amount of snow, and then I see the pictures and I'm like, you liars. Because like that's like an Edmonton summer.
So two narratives that we need to focus on. One is the state's case. The state's case is that Karen Read struck John O'Keefe with her vehicle in backing up, and that was the cause of his death. Okay. And narrative number two is the narrative the defense wants to introduce, which is the idea of a cover-up, and that John O'Keefe died by some other means, and wants to introduce. We don't get, and here's the thing, you don't get this.
Now, was it a cover-up or was it a blow away with a leaf blower?
Oh, we'll get to that. Getting to third-party culpability is almost impossible in any criminal.
I'm guessing they just didn't have a flamethrower to use.
But here we are, and the first words out of defense counsel's mouth in opening statements was, what was it? She was framed.
Karen Read was framed. So that's a hell of a start.
Them be fighting words. And the trial
he's picking all the fights.
He's doing a job.
I'm totally there for it. He is absolutely like, quite frankly, that's heroic. It's badass. So, and he's just, well, both of them. I'm forgetting their names now, but both of the
Jackson
defense
and
lawyers,
Yannetti.
yeah, they are kicking so much. Oh, they're
different styles too, which is interesting.
The thing is,
we got some more Yannetti today. It was
different styles, but also when they're doing like the various sort of techniques that are of cross-examination, they both just do them really smoothly, and it's so lovely to watch.
Now today I have a take on it that I think it's kind of, I've listened to a certain part of the cross-examination of one of the state's chief witnesses, and I think that some of the wind got taken out of Jackson's sails post proffer or post voir dire. So we'll go through that. That's kind of the area I want to focus on. But getting up to today, so the first 3 days of trial, essentially you had first responders that testified, and this is the basics of the testimony, that they came upon Karen Read, who was performing CPR at that point in time, or had looked like she was performing CPR, had blood on her mouth that presumably she obtained from performing CPR on John O'Keefe. John O'Keefe was on top of snow, but not covered in snow, though the snow was falling at a very rapid rate at that point in time. The paramedics then we don't have an accurate description, or we don't have a consistent description of what he was wearing. Some people are saying he was dressed appropriately for the weather, freezing cold and snowing, and other people were saying he was dressed inappropriately for the weather. He was wearing a small sweatshirt or a light sweatshirt. So we don't know. There's no testimony as to any tears in the sweatshirt, but there's testimony as to lacerations on the skin. I have questions about that as well. And then you have testimony from the paramedics who say in varying fashion that Karen Read said on multiple occasions, I hit him, I hit him, I hit him, I hit him, I hit him. 4 times. I think I just said 5, but 4 times. But each one of those witnesses gets essentially shredded on cross-examination to the point where they admit that their narrative or their version of the events now might differ from what's reflected in the reports. And maybe it wasn't that she said, I hit him, or it was a question, did I hit him, etc. So we don't know where these people are during the time of this statement. The state seems to be placing a whole lot of weight on this statement by Karen Read. By Karen Read. And today we get to hear from the witness that is the only person so far who
now one of us is having a problem on the assumption that it's okay. I was like, on the assumption that it's Rob, I'm going to keep talking.
My internet cut. So
did Leo get a hold of a wire?
No, I think the internet decided it was going to be strange. Where did I freeze? Where in the narrative?
Like 20 minutes ago.
Don't say that.
I'm kidding.
Was it the hoodie thing?
It was before the hoodie thing.
No. So there's competing testimony as to whether he was appropriately dressed or inappropriately dressed, whether he had a heavy jacket or light jacket. Then a lot of the state's case turns on the statement of Karen Reed, I hit him, I hit him, I hit him, hit him. Or did I hit him? Some version of that. We don't know who was present when this was said. And during cross-examination, the jury is kind of left with a lot of confusion about where people were, whether they could hear, whether they were in the ambulance at the time it was said with the ambulance doors closed, whether this was something they're just repeating that was said by one of the other people who were observing it. We have so many questions because the cross-examination has been brutal and meticulous on the facts.
Well, and the thing is that they have so much to work with on the crosses. Like the prosecution, I think, needed to take a moment to look at their case and be like, we actually have some problems with this one. And like, why? The one thing that we've seen lampshaded that we haven't actually seen in testimony yet, but it's going to come out, is Proctor searching the phone for nudes.
Oh my God. Yeah, I forgot about that part. How did I forget about that part?
I feel like you just blocked it out as trauma.
I might have. Trooper Proctor, who's the lead investigator, apparently within a couple of minutes of, looking at Karen Reed's phone, was texting his buddy saying, I couldn't find any nudes. So that happened.
This, by the way, is an excellent reason to have like pictures of, some random person's taint on your phone. Because if they're going to look through your phone, it should be unpleasant.
It's a terrible idea. Why would I? That is an awful idea.
Just make it unpleasant for them.
Yeah. Yeah. So, wow. Okay.
Oh yes, and this was not like a search with a warrant.
Yeah, it was a warrantless search. He was just scrolling through the phone.
So yeah, this was just him poking around.
Yeah. And then the people that are on the scene, when they go to start looking for like items and materials that might be around the body, they decide, you know what, this is a great tool the great tool to do this, a leaf blower.
And that's only because they didn't have one of those flamethrowers from the from that. So
yeah, so you have a leaf blower that's brought out to help search for items in snow, because sure, why not? That was a decision.
The critical thing when you find evidence is to make sure that it is completely moved away from its original context and like, yeah.
So today we got to hear from Katie McLaughlin, who was she ended testifying yesterday, and the state brings her back up today for, I think, one question. Then we get to cross. But the crux of McLaughlin's testimony was that Karen Reed said, I hit him, I hit him, I hit him, I hit him, in her presence to her or to someone else in response to one of her questions. We're not sure.
You notice that like every single witness says, I asked a question and, and she said, I hit him in response to that question. I'm like, who asked the question though? Because you all say you were doing the questioning, not that you overheard her saying it to someone else. So like, is she supposed to say this to everybody?
You know what else they didn't answer that's driving me nuts? There's a cop there during this questioning.
Was she ever read her rights?
That's my question.
The thing is that would have been dealt with in a motion in limine. So
I know.
So I assume that they're saying that if the statement was made, that it was admissible.
Now, McLaughlin is the only one who the defense cannot throw doubt on as far as being next to Karen Reed, because McLaughlin was tasked with getting John O'Keefe's medical history from Karen Reed. So she was the one that was communicating with Karen Reed almost the entire time. So her testimony and the credibility of her testimony is crucial to the state's case. Well, let's pick up there. because it's really fascinating. You guys got to let me know if you can hear it and if it's too loud or too quiet. Let me see if I can throw closed captions on. Nope, they're not available for this one, but it should be loud enough.
All persons have any business before the ER 117. The Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your
Is that
Honor.
too
Laura
loud?
McLaughlin for the Commonwealth.
Good morning, Ms. Mc-
Is that too loud or is that normal?
No, that seems fine to me.
McLaughlin.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Your Honor, Elizabeth Little, also on behalf of the Ministry.
Good morning, Ms. Little.
Good morning, Judge David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. I have to ask you
Good
the
morning,
same
Moon.
three questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded.
I'm surprised they haven't had a juror just be like, check, please. No, I talked about this to everybody.
Research or investigation into this case.
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their hands.
Somebody stands up and is like, I heard that it was. and just blurts out some critical piece of evidence.
All right, so we begin with a sidebar, and then while we do the sidebar, I think Court TV might zoom out and give us a look at the courtroom, because the courtroom that they're in is, I mean, oh, we don't want the booger picking. Nope, let's go past that.
No, you sure you don't want to like turn that down to half speed?
No, the courtroom is itty bitty. I mean, I've been in some small courtrooms like in juvenile court. This thing is teeny tiny.
This thing is. I think I've been in courthouse bathrooms that are bigger than this courtroom.
So, and the gallery wraps around the table. So I've been so
That's
fascinated.
weird that it's a fishbowl. Oh, and this looks like
That's
those
family.
look like, yeah.
I think, yeah. Let's get on the record. Come on, Judge.
And it's weird that some of the people are sitting like at the defense table, like or at the defense area. I don't know what to make of that, if anything. What, if anything, to make of that?
I hate you.
No, you don't, but you hate what, if anything.
Truth and nothing but the truth, so help you God. Thank you.
Side note, if you get claustrophobic, this witness box is not for you. Like this, I'm not a small person. I don't know that my shoulders would fit. Like this, it's tiny. And the judge basically asks every witness, you can sit or stand, whichever you're more comfortable with. The standing would be a baller move, but
I was going to say, if I'm ever given that position, I'm going to stand because like, okay, defense lawyer or, prosecutor or whoever, now you get to cross-examine me as I loom over you like I am some 13-foot tall giant. Like, you can talk to my crotch to cross-examine me. Let's do this.
before we get into the testimony and before we get into this, I know that people are going to have opinions about the credibility of this person's testimony or what they are saying. Those opinions are fair game. You're allowed to have those opinions. You're allowed to combat the testimony. You're allowed to doubt the testimony. I ask that you do that in a respectful fashion because you know what? YouTube doesn't like when we get really nasty with that kind of stuff. And plus, I like keeping the chat rather, cordial, back and forth, people having debates over law. What you're not allowed to do and what's not against kind of channel guidelines here, we're not allowed to bash people for who they are. Ian and I might tease about Sam Bankman-Fried or stuff like that, but when we're talking about witnesses testifying, especially in a trial like this where the information is sensitive and you actually have a real victim, Officer John O'Keefe, who is no longer with us, whose family is in the courtroom, who are seeking some form of justice, whether it's justice against Karen Reed or the perpetrators, whomever they may be. So we try to keep the chat respectful and on topic when we're talking about testimony being presented in court because court's stressful. So please, that's just my comments, my request that we try to be respectful when we're observing this courtroom testimony and the conduct of the attorneys and judge. Also, if you hear heavy breathing into a microphone, it's not Ian or I. It's either the judge or a witness. I don't know.
It might be me.
If the gain is turned up like 9 million%, But there's a lot of breathing, and it's been rather frustrating because the judge seems to sigh into the microphone
Whenever the defense makes a point.
I know. So that's just kind of a caveat, trying to keep respectful, but you can question the hell out of the testimony. I have no problem with that.
Whenever you're ready, Mr. Lally.
Fashion choice. Do you think the crucifix was an intentional move here?
Now,
Hold
I have a few more questions for you. So, like, turn your attention to the period of time you testified about yesterday when you're at Mr. O'Keefe is in the back of the ambulance. With respect to his clothing, what, if any, observations did you make in regard to that clothing?
He had, in terms of what he was wearing.
First, in terms of what he was wearing.
He was wearing jeans. He had on a dark colored light zip up jacket. And I noticed one sneaker.
Now, with regard to that clothing, what, if any, observations did you make in regard to the condition of that clothing?
It was soaked through.
We don't know where the sneaker
As
is yet.
far as tears or holes or anything else with regard to that clothing, what, if any, observations did you make of that?
I didn't see any.
I don't know why the prosecution did that. I don't. We'll get to the picture. So remember, I didn't see any tears in the clothing, and remember, light zip up. Okay.
Ms. Gilman, if I could have exhibit number 18.
This is the photo.
May I approach the witness room?
Yes.
The house. A lot of snow. Well, that's fair. There's snow. Some amount.
Yeah, I'll fight you on how much.
Now, first, Firefighter McLaughlin, do you recognize what's up on the screen as exhibit 18?
Do I recognize
Recognize
what it is?
Yes.
Yes.
And what do you recognize it to be?
The address of the call, 34 Fairview Road.
Now, with respect.
Now, can you tell us the exact directions to drive there?
Or where Mr. O'Keefe was on the ground when you first arrived?
From this angle, no, I don't.
And if you could, it was not on the photograph. Is it off to the left, the right, or where would it be in relation to this photograph?
To the left.
Oh, the
say.
breathing.
And about how far off frame do you believe it was?
I'm not sure. So my view of the call was, my reference point wasn't a house on either side. The patient was off the road. So my view of this call was the patient was on the side of the road. The only thing that I noted was a fire hydrant. So in relation to, I know it was to the left of a house, but I'm not sure exactly how far left it would be from this picture, from this angle.
So your memory is to the left of the house near a fire hydrant, is that correct?
Yes.
Take that down. I have no further questions.
My first critique and commentary. Why would that be the last question you ask of this witness? Like you waited overnight, you had like all the testimony, and you get back up, and the last questions you're asking is, do you remember where the body was in relation to the house?
I
Why wouldn't
honestly
you end with the strongest part.
I would have either brought it back to some good mic drop moment if you've got one, or you just come back the next day and you're like, no further questions. Over to cross.
Yeah, especially because you have that in already.
Yeah, like 7 times. Like that's so established where it is. Just let it go.
So that part bothered me. Now here we get our first look at defense counsel Jackson.
All right, cross-examination.
Thank you, Your Honor.
This isn't our first look at him. He's
No,
he's dealt with some other
for
ones.
today.
Fair. I mean, it's our first look at anybody for today.
Good morning, Ms. McLaughlin.
Morning.
You responded to the call of an unresponsive male in the snow at 34 Fairview. That was the address you recalled, correct?
Correct.
The house you just looked at, that is in fact 34 Fairview, right?
Correct.
As Mr. O'Keefe was being transported by ambulance, you were instructed by firefighter Flamati to get information about the victim from Karen Reed, correct?
He wasn't being transported by the ambulance at that time. He was on the stretcher. And Tony, who was at the head of the stretcher, asked me to get information.
Already combative. So she's already
Yeah.
combative and she's giving longer answers. Now, Jackson, what he should do here is he should immediately redirect to some quick questions to get her pointed in one-word answers.
From Miss Reed about the patient, but he wasn't being transported in the ambulance at that time.
Who's Tony?
Firefighter Flamati.
Got it. When you did, in fact, did you follow those directives?
I did.
When you finally approached Miss Reed in order to get that medical history as best you could, what did the scene look like? Who was with you or around you?
So they started to move the stretcher towards the ambulance. Miss Reed was sort of, I guess I would describe it as moving around the scene. So she was moving, kind of going in circles. So I was really just focused on her, trying to get her to converse with me and get those questions. So that I wasn't really noticing anything else at that point. I was more just trying to contact her, and she was moving around.
What were you wearing at the time?
I had my like winter fire jacket on.
What color is it?
It's yellow and red.
Bright yellow for safety purposes.
Yes.
When you began your actual questioning, once everybody sort of stood still, when you began your questioning of Miss Reed, you were standing in one spot, Miss Reed was standing to your right, is that right?
Well, the questioning started, as I said, she was moving around the scene. So the questioning was ongoing as she was moving around to different locations. I don't know exactly how many of.
So this is a tough witness. This is a hard witness. Like if it already
She's immediately defensive and putting up all the walls
but not coming off that way yet. Now, Jackson's job has to be to get this witness to appear defensive, not just that, because right now she's just giving narrative answers. It might not be the exact answer he wants, but she's giving answers that are responsive. So he's got to be careful, because if he comes in too aggressive, it makes her look very sympathetic, and that's not what he wants. So he has to navigate the evasive answers in a fashion that doesn't appear too combative. That's like, these witnesses are super hard to attack.
Sometimes you can do well just pointing out that they're being combative. Like, and sometimes you can put a witness on their heels by just saying like, you're answering you're answering differently now, aren't you?
He does that, but not yet. It takes, he gets a flow going. Like, it doesn't feel like it, but this is the nice guy routine. Like, he gets a flow going and he starts to shift slowly, because he knows he's got to shift the jury over, because the jury's just heard this witness give some of the most impactful testimony, and you can't just come straight out and attack. So
sometimes you can, but you have to have earned it. And I don't know that they're there yet.
Of the questions I got out during the time that she was moving around, at one point we did come to a stop, and at that point she was to my right.
That's the point I want to focus your attention on, if I could. When you came to a stop, that's the point at which you recall the statement being made that you attribute to my client.
Yes.
Okay. And in that group, who was there? I want to make sure I understand this exactly.
So there was Miss Reed to my right. There was a civilian woman to my left. There was a police officer who was not directly across from me, but I would say maybe diagonal to me, closer to Miss Reed.
Clowns to the left of me, jokers to the right.
Your Honor, I'm holding a photograph. This will be shown to the Commonwealth. May I approach?
Yes.
I'll show you Ms. McLaughlin a still photograph. I'm going to ask you to take a quick look at that photograph and look up after you've studied it for a second and tell me if you recognize people that are in that photograph.
I recognize people in it.
May I publish, Your Honor?
Yes. Is this an exhibit or are you moving to introduce it?
I'm moving to introduce it. It has not been introduced as yet.
She identified.
Um,
Let me do this.
so go ahead.
It's a frame. Closest to the camera.
Yes.
In what appears to be a yellow and red jacket.
Yes.
Who's
All right. So there she is, yellow, red jacket, middle frame.
that?
That would be me.
Who's to your right?
It appears to be Miss Reed,
And to your left?
a civilian
Sasquatch?
woman,
And across, as you said, sort of diagonal, closer to Miss Reed is,
a police officer.
do you know that officer's name, by the way?
I don't know his name.
Your Honor, with that, I would ask that this be marked as next in order.
Okay. Is there any objection?
No objection.
So we are going to remark these exhibits.
Yeah, we
How
got
do you want to do this, Madam Reporter? I don't. Tori, how many are in evidence? Folks, it's my responsibility. 1, 3 appropriate. For the next want to waste your time.
Yes.
All right. So
I see people being like kind of combative with the judge. The judge does great with jury management. I don't have a lot of issues with this judge. I mean, she does great with jury management. She's very kind. She explains the issue when she gets to the jury viewing explanation. Great. I also don't hate the whole only say of the word objection. People have had a big issue with that. I don't have an issue with that. If you want to preserve the record and you feel that your objection needs more time, you say, Your Honor, may we approach? And she has never denied a sidebar. If the judge says objection, if you say objection and the judge says sustained and you say, Judge, may we approach? And the judge says no, that is a record issue. But she has never denied a sidebar. So I wish that she would maybe not sigh, but I don't have a lot of issues. It's bad.
The sighing is bad, and especially the sighing is bad because it seems one-sided. And so if the jury can hear those sighs, I would have
that's the problem.
A real issue. But I suspect they can't, because I can't imagine that the defense would be sitting there like not raising that if the jury can hear it.
But here's the thing: even if you can't hear the sigh, you can see the body language of someone sighing. Like if the jury is observing the judge, there's something that goes with that. I don't like that
fair.
at all. So I don't know. I'm withholding judgment on the judge right now until I see more, but I don't hate how she controls the courtroom.
You're withholding
any
judgment?
Yeah, I know. It was a weird phrase, but it is what it is.
to that from the Commonwealth?
No, Your Honor.
Okay.
Thank you, Your Honor. May I?
Yes.
Thank you. Ms. McLaughlin, this is the time or the scene that you've told us about when you heard the statement that you've attributed to my client, correct?
Sorry, say that again.
Sure. This is a moment in time, it captures a moment in time when you're standing there. To your right is Karen Reed, which you've described. To your left is a civilian female, which you've described. And across from you is an officer, which you've also described.
Yes.
So this would be the time or close in time to the time that you heard the statement that you attribute to Ms. Reed, correct?
Yes.
The first time you ever made that official report or an official report to law enforcement regarding that statement was January 30th, 2022, correct?
Well, yes and no. The statement was made in front of the police officer, so that would technically be the first time that that statement was
Except the
made
police
to-
officers already said, "Yeah, it probably
in
didn't
my
happen."
presence. And then, yes, I testified to it on January 30th, as you said.
You said it on January 30th. You weren't testifying under oath, correct?
Okay. Said it.
Okay.
Yes.
My question was really, and I appreciate you clarifying, my question was really the first time you actually told this statement to any law enforcement officer was on January 30th.
Yes.
Okay, we can take that down.
Excellent witness control. You don't realize how hard those questions are because you're in a super complicated timing. Like to get that question specifically stated and to keep the witness focused and take the evasive answer, not seem disrespectful, but to get the witness trained back at what you're asking and
Oh, yeah,
getting
that
that
was
nod
tough.
and yes.
That was when you met with Trooper Michael Proctor, correct?
Yes.
Obviously, that was very close in time to the event. It was the next day. Is that right?
Yes.
The events were close.
The 29th. Yeah. So it would be the next day.
Right, 29th, 30.
Yep.
Okay. The events were fresh in your mind at that time.
Yes.
You obviously knew about the importance of that interview. You knew that it dealt with a police officer who had passed.
I knew it was important to talk to the police about what I heard.
And you wanted to be accurate.
Yes.
You wanted to be as detailed as you possibly could.
Yes.
And you understand that memories, obviously, they get a little worse with time, not better with time, right?
Sure.
The closer in time you are to the event, the fresher your memory is going to be about the details of that event. You would agree with that, right?
Sure.
You told Trooper Proctor
You notice
the day
you
after
switched
the
from
event,
yes to sure.
on January 30th, that the statement that you attribute to my client was actually made to the female, not to you in response to your questioning. That's what you told Trooper Proctor, correct?
I don't have those notes in front of me, so
Hunter has some thoughts.
I don't know that I can tell you that that's correct, but the statement was made in response to my question. However, the Miss Reed was looking at the civilian woman as she said that.
Does it refresh your recollection that what
Don't read what you think refreshes a recollection. You can show or you
Yeah,
cannot
right.
read it.
That is not a bad call. That's a good call. I love how fast the
That's
judge
fair,
was
yep.
doing that. Like that was great. Love how quick, and the judge is quick on those. Like, no, you're not about to read something in open court. The judge knows these attorneys are damn good.
Yes.
take a look at the highlighted portion of that report and look up when you're finished.
Okay,
May I?
sure.
Your Honor, may I
Yes.
approach? Does that refresh your recollection about what you told Trooper Proctor on January 30th?
Yes.
And you told Trooper Proctor,
No,
quote,
let her,
in turn,
hold on, I'll see you, Ted.
That was a bad interruption. That was a completely proper question. I don't know what it was a proper question. Did it refresh your recollection? I think the judge was kind of saying, you can't say what's on the page. And he's going to say, no, I'm not. I'm going to cross her on this issue. It refreshed your recollection. So he gets to ask the question.
may I, Your Honor?
Yes.
In fact, what you told Trooper Proctor was,
There you
quote, Karen then turned to her friend and stated, I hit him, I hit him, I hit him, I hit him. End quote. Correct?
Okay.
Is that yes?
Yes, if you're saying that's in quotation marks in that, then yes.
That's what's in the report.
Okay.
And you don't have to agree with me. I'm asking yes or no questions, not okay?
Yes.
Okay, thank you. So in fact, what you told Trooper Proctor was that Karen Reed looked at the female to your left and said 4 times, I hit him, I hit him, I hit him, I hit him, correct?
Yes.
And have you since learned that the name or identity of the female that was standing to your left?
No.
You're aware that the female that was standing to your left reported the exact same statement?
No.
are you aware that the female standing to your left reported that exact same statement as, could I have hit him? Did I hit him? Did I hit him?
No, I'm not aware of that.
You then went back to the ambulance after you heard that statement that you believed you heard my client state.
Yes.
You opened the ambulance door, correct?
Yes.
That was the back door,
The side door.
the side door. And there were two firefighter paramedics in that ambulance at the time, correct?
I believe there were more than 2 at that time.
2 of them included firefighter Nuttall and firefighter Flamani.
Yes.
And at that point, you told them,
The 2 firefighters who also reported hearing the statement. But listen to what he just said. That you opened the door. So they were, from her testimony, they were inside of the ambulance, inside the closed ambulance when this took place. And that after she heard this, she goes and opens the door and tells them. So when they're testifying under oath, I heard her say this. That's completely contradictory to this testimony.
Also, they said that once the doors were closed, they didn't open them open them again.
Correct.
So all of this makes no sense with the prior testimony.
No. And I'm not coming out and saying it's intentionally this way. I mean, heck, it might be. I have no clue. But it is inconsistent.
what you believed you had just heard.
So I went into the back of the ambulance. I said, this is his name. This is his date of birth. She says he doesn't have any medical history or allergies, doesn't take daily medications. And then I said, she's saying I hit him.
He's allergic to being beat up and left in the snow.
Motioned to his face and said something.
Ask another question.
So the answer to my question is yes, you told in front of Flamati and Nuttall the phrase, I hit him.
Yes.
Did you write that in any report?
I don't write a report in this scenario of my job.
Let her finish the answer, please.
So there are 2 people that will write reports.
That was improper. He was right to cut her off. It's kind of a leash I don't think should be on the council, but I'm not there.
In my department on a call, one being the lead paramedic and the other being the officer who's on scene. So those are the people that write reports, and I was neither of those, so I did not write that in a report.
Okay.
That's correct.
So let me ask the question again. You didn't write it in any report?
No.
You didn't write it in any notes?
No.
You didn't document that statement in any way whatsoever, correct?
Other than my interview with Proctor and my subsequent testimony.
You didn't document that statement in any way yourself, did you?
No.
Since January 30th, in that conversation that we just talked about with Trooper Proctor, your statement has evolved. Is that right?
I love the use of that word, evolved.
I don't know how to answer that.
You testified yesterday to something quite different.
Because evolution doesn't
quite
necessarily
different.
imply something's getting better.
Outside of what you stated to Trooper Proctor.
This part. He's gonna-
Respectfully, I think my testimony has been pretty consistent.
You testified to something yesterday quite different in context than what you told Trooper Proctor. Isn't that right?
I don't know that that's right.
Well, you told Trooper Proctor, Karen Reed looked at a female standing to your left, said, I hit him, I hit him, I hit him, I hit him. Right?
Yes.
Yesterday, you told these jurors that Karen Reed said, I hit him, and an officer said, you what? And she repeated, I hit him, and the officer immediately turned and went to find another sergeant. Is that right or no? Yes or no?
No, there was more to that testimony.
That's not what you said yesterday?
I think I said more than that, than what you just repeated.
Is
Side note, did you notice how he said you told these jurors and how the tone he used and how it didn't come off like, are you telling this jury? And how much I hate that phrase. The use of yesterday, you told these jurors. Like, it was a very, he's not trying to sound like Perry Mason, but he sounded like Perry Mason when he's doing it.
What I said, consistent with what you said yesterday. There's a lot of things that you said. More of. I'm asking, is that the sum and substance of what you told these jurors yesterday?
Yes.
So you would agree that from that time till yesterday, your story has evolved. It's changed.
Would I agree with that?
No.
I don't know that I agree with that.
You think the story that you told Trooper Proctor is exactly the same
I
story?
understand what you're saying. So I understand what you're saying.
So has your story evolved?
Then answer
Okay,
the
yes.
question if you understand it.
Boom. Like, it was pulling teeth, but he gets there. And she says it. She goes, yes, it evolved. So there you go. That's a slow roll to it, a very effective cross. Like, because he got her to basically say, yes, the story changed.
Ms. McLaughlin, who's Caitlin Albert?
I went to high school with somebody named Caitlin Albert.
Okay.
That's
Okay.
as much distance as you could possibly.
I knew none of the players of this trial. Knew
Me
none
either.
of the shade, none of the allegations, none of everything other than what I've seen in this trial. And the second that she responds to that question, I was going, oh, that's an answer. What the hell are you talking about?
Yeah, that's about to go very wrong. You could just. It's a question you don't ask unless you could back it up. And this is one of those questions that really tends to parse out the truthful witnesses from the BSing witnesses. And that just smells either that the lawyer is fishing, which these
No,
these lawyers might golf, but they do not fish.
knew they weren't fishing. She knew damn well that they knew. Like,
Yeah.
that whole. Let's listen to that. Let's listen to her
But
answer.
she's testing them. She's like, I know what the answer is, but do you know what the answer is?
Now we're gonna get to the next part, and then I'm gonna tell you why I think Jackson's kicking himself a little bit. At the end of today, because there's two parts. But let's listen to the answer one more time.
I went to high school.
No spinning wheel. Stop. Internet, behave.
Ms. McLaughlin, who's Caitlin Albert?
I flash.
I went to high school with somebody named Caitlin Albert.
Somebody named Caitlin Albert.
I love the emphasis.
I went to high
too.
school
That's
with somebody named
objectionable,
Caitlin Albert.
So do you know Caitlin Albert?
I do.
You're friends with Caitlin Albert?
I would say more acquaintances, not close friends.
How do you describe an acquaintance?
I would say that we have mutual friends, so we might see each other occasionally because of mutual friends, but we don't have
We
a
don't take
one-on-one
selfies with each
friendship
other?
or hang out regularly.
Fighting this.
Who's her dad?
I don't know.
The objection system.
Do you know who her family is?
Objection.
Sustained.
Maybe we put
It should have been
Yes.
able to ask that. All right. So jury gets excused because now we're going to do voir dire. Now they want to have some back and forth with this witness outside the presence of the jury. Those questions were something. Those questions were something else. She said, I would consider her or describe her as an acquaintance, not a close friend. Well, there's an in-between, and it's called a friend. Like, there's close friend, there's acquaintances, but like, there's also just a friend. And I'm going in my head, why are you fighting this? Why are you fighting it? And we start to kind of see why. Now, this is outside the presence of the jury, so he's going to get some latitude on the questions he gets to ask. Did you catch this part earlier already?
No, I didn't catch much of any of today.
Oh, you're very much going to enjoy this part.
Oh, I'm already
Ms.
enjoying
McLaughlin,
it.
I asked you before we broke if you know who Caitlin Albert is.
Yes.
You said that you went to high school with somebody by that name, correct?
Why is it- Yeah.
I know her.
In fact, know that person as a friend.
Hang on. Is it saying, like, is your screen showing Court TV live court to resume?
Yes. Yep.
Oh, I guess we're only going to get audio of this part for right now. This is a Court TV issue.
Yeah, it is what it is.
It is what it is. All right, audio.
Zora, what is it you want?
Pets.
She's Mrs. Runkle is away. That's part of why I'm able to leave the door
Mr.
open.
Jackson?
That's correct.
Okay. When did you get these?
Oh,
But-
all right.
It's a
So he
paper
wants
mark for identification that appear. You got these off of social media sites, Mr. Jackson?
That's correct.
Okay. When did you get these?
I couldn't tell you the exact date, but we probably have them for between 6 months and a year.
All right. And Commonwealth, you've not seen these before?
No, Your Honor.
All right. So we'll talk about Rule 14 in a little bit, but we'll bring the witness in. You can ask her questions, Mr. Jackson, about her vacation that you mentioned, the drinking that you talked about, the relationship with Ms. Albert. I've forgotten the first name already. And Caitlin, and about the house. So you can ask her questions about that. And let's see, you can show her these exhibits or these marked for identification if you need to. You may have trouble actually getting those into evidence, but I'm going to let you find out. You can ask her to identify them, how long ago they were, things like that.
Thank you.
All right, could we bring in Ms. McLaughlin, please? Yes. And Commonwealth, you just saw these today. I'm sorry, I don't remember if I asked you that.
Yes, and yes.
And you were objecting that.
bullshit. Bullshit. There's no way they are just now seeing social media posts of one of their star witnesses. There's no way.
I mean, it's possible that they didn't do the research. They have not struck me as super diligent, but so this is something that's surprising me. There's a defense obligation to share discovery here.
If you intend to use it, this is pure impeachment, though. The judge gets this ruling completely wrong.
But that's bizarre to me because, like, where I am, I don't have to share a damn thing.
I know. So Massachusetts has a rule that requires Rule 14, which is one question in the chat, which requires the defense to give the prosecution any documents or evidence it intends to use at trial.
Yeah, I don't have to do that at all.
But this isn't something you intend to use. This is pure impeachment. It's not something you intend to use unless the witness opens the door to being impeached. If she had basically said, yeah, I know this person, they're my friend, I've gone to the beach with them and hung out,
then they'd never tender it because
it never comes in because you don't have to go after her credibility. So this ruling is just wrong. So what, if anything, took place? A bad ruling in this regard? Thank you, Yellow Pill. Hang on one second. I was saying there's another question I saw in here. Phoenix Waller, the lack of scene documentation is maddening. It really is. They don't have body cams in this jurisdiction, so you're stuck with dash cams, which are terrible in a snowstorm. Bravo Chick says the judge goes all Bill Lumberg from The Office Space. Yeah, if you could renumber these exhibits, that'd be great. That's not that bad. Sarah asked a question here is maybe a dumb question. What's the difference between showing the witness evidence and admitting the evidence? Why not admit everything if it's used during trial? Some stuff you cannot admit. Like, for example, this. You might not have foundation to admit social media posts.
I mean, let's say I show somebody a picture and I say, do you recognize this picture? And they say, yes. And you say, what is this picture? And they're like, we photoshopped it because we thought it would be funny. Now it's a fake picture, right? The only evidence you have is that it's a fake picture. and they're like, they're not admitting a fake picture.
Or, for example, the prior statements. So the prior written statements, that was a statement given to the officer that is pure hearsay. It's not admissible at all. It's written down in the officer's report and it's there, but you don't admit that statement because it's not evidence, but you use it to impeach the witness. So they're allowed to read it to refresh the recollection or to for purposes of impeachment, but the jury shouldn't see the written statement because it's not admissible. It's inadmissible hearsay, but it can be used to refresh the witness's memory. So that's why you don't admit everything, because there's rules of evidence to prevent that from being admitted. Let's see. There was another one that I saw too. Where was it? Lost it. This isn't really a question that's relevant, but Tracy Fagan, good on you. Rob, did you know it was snowing? I did. We have 7 witnesses that. Okay, going on.
I believe that one of the witnesses testified that the weather outside was frightful.
You objected to sidebar that these come in at all.
But in here, it's so delightful.
Oh, here's the 4th one. I'm sorry. Mr. Jackson, here's the last one. All right. So, Ms. McLaughlin, Mr. Jackson's going to be allowed to ask you questions outside the presence of the jury, and you're still under oath, and you have to answer them truthfully. Okay?
Okay.
Emily was wrong in this initial judgment. This issue isn't the pictures is not being, they're not being excluded because of the foundation issues. This is being excluded because of discovery violation. It gets brought up later. And Emily actually did cover that later as well. So it was a discovery issue. They actually do a proffer at the end of testimony.
Ms. McLaughlin, when just briefly as a predicate, when you stepped out, I just want to make sure we're very clear. Did you have a conversation with anybody from the Commonwealth between the time you walked out of court and just now?
Just about if I needed a drink of water or to use the restroom.
Okay, but nothing about the substance of your testimony?
No.
Ms. McLaughlin, I asked you before we broke if you know who Caitlin Albert is.
Yes.
You said that you went to high school with somebody by that name, correct?
Yes.
You in fact know that person as a friend, correct?
I know her.
She's more than an acquaintance.
I would say she's an acquaintance. She's not a close friend.
Is she in a group of friends of yours?
We have mutual friends.
How long have you known her?
Probably since high school.
When you say, and I don't want to ask your age, I wouldn't do that. How many years, how long of a span of years have you known her?
Since high school, so maybe 10.
And you know her family, generally?
I don't.
You don't know anything about her family?
I don't know her family.
Had you ever been to her house?
All right, hang on. I hate doing this. I'm going along crime because they actually have the video. Give me 1 second. Let me switch the feed over. And I got it queued up right on the time.
I don't know her family.
Had you ever been to her house?
Not that I recall ever being there.
Not that you recall, or you haven't? There's two different things.
I don't recall ever being there.
Okay, so you might have been there, you just don't recall.
I don't recall ever being there.
Okay. If I were to ask you if you have ever been to her house, yes or no, you cannot answer that because you don't know. You cannot recall, correct?
Why are you fighting this?
I would say
Because she knows the answer is bad.
no. I have no recollection of ever being at her house.
Are you friends with her on social media?
Yes.
May I approach her on her?
Yes.
I'm just going to leave all 4 of these up here. I know what they look like. Can you do me a favor and take a look at the first document? What does that document appear to be?
It says Caitlin's friends.
What does it look like? That's a printout of.
I'm sorry.
Okay,
I
back to
would
court.
say, I mean, I would lean towards no. No, I have no recollection of ever being at her house.
I hate the ads on long.
Are you friends with her on social media?
Yes.
May I approach you on her?
Yes.
I'm just going to leave all four of these up here.
She's gone full shrug, by the
Do me a
way.
favor and take a look at the first document. What does that document appear to be?
It says Caitlin's friends.
What does it look like? That's a printout of.
I'm sorry.
What does that look like? It's
No, exactly. Some social media.
okay. Under Caitlin's friends, do you see your handle, for lack of a better phrase?
I do.
Okay. Is that you?
Yes.
Can you look at the next photograph? Before we talk about that next photograph, which is,
Did you see the eye roll?
I should go on the record, Your Honor. The first one was H.
Sometimes it's fun to put that stuff on the record. Did you just roll your eyes at me?
Before we talk about I, which is the next photograph, how long have you been social media friends, quote, friends with Caitlin Albert?
I don't know.
More than 5 years?
Probably.
More than 8 years?
I don't know.
The second photograph, or the second document, appears to be a photograph. It's I, is that right?
Yes,
Do you see yourself in that photograph?
I do.
You see Caitlin in that photograph?
I do.
When was that photograph taken?
I have no idea.
Where was that photograph taken?
I don't know.
You have no idea how long ago that was?
I don't.
What was the
Bullshit.
Of course it
Like-
is.
Bullshit. I'm sorry. You have no idea how long ago that was. There's no way. If you show me a picture of like me back in high school or college with like a bunch of friends at like some place, I can probably pinpoint it to, oh, those are my college years because those are my college friends. Or it was the summer of, after my senior year.
Yeah.
event that was depicted, or that is depicted in that photograph?
I don't know.
Is that local or was that on a trip somewhere?
I don't know. Probably local. If it's a beach, I don't remember. I've never been away to a beach on vacation with all of these people, so probably local.
When we say local, let's talk about local. I don't mean, we may have different definitions. Where would that be? What beach? I'm not as familiar with the location.
I'm not sure.
Maybe on the Cape?
Possibly.
Do you recognize some of the other folks in that photograph?
I do.
Matter of fact, there's a lot of people in that photograph, right?
There's a lot of people in it.
Did you take a trip with all those people at some point in the past?
Take a trip.
To the beach?
Did I go to the beach at some point with these people? Yes.
Okay.
Here's the thing. Jackson's hating this right now. People think if you think he's loving this, he's hating this.
No,
You know
this
why
is
he's
just
hating this?
like,
Because this is in front of the jury. This is just in front of the judge. This doesn't matter. He's getting every evasive answer to the dumbest questions, like trying to narrow it down, but it's not in front of the jury. He hates this.
well, and the thing is this is just chores. This is just pulling teeth.
Oh. Because you can't duplicate this. Once you go through that teeth pulling, they're not going to force you to go through the same teeth pulling in front of the jury.
She might.
She learns.
When did you go to the beach with all those folks?
I don't know. I don't know when this picture is from.
Have you
It
gone?
seems old to me, but
Well, you can see yourself. I mean,
yeah.
What was that? Did you say it seems old to you?
to me.
Okay.
This isn't like a recent to me.
how old do you think that photograph is?
I don't know. It could be around high school. I'm not sure.
And I know Mr. Jackson didn't want to ask you how old you are. When did you get out of high school?
2014. I
Okay.
I
graduated.
like how she just gives that there.
Yeah. So that makes her about what, 28? So I just did the quick math. Yeah, about 28. So you're talking about what, 2014 to now, a 10-year period? Come on, I forget a bunch of stuff. But
Oh yeah, this is complete.
now I have suspicion as to why she's being a little bit evasive about it, because I think one of those photos, she's drinking a beer in it. And I don't know if she's legal age to drink the beer in that photo, but who the hell knows?
So could that have been around 2014?
It could be.
So you've known Caitlin for at least that long.
Yeah.
And when I say travel, I mean travel outside of Canton, gone places with her, correct?
Yes.
Posed for photographs with her,
Yes.
with other folks.
Yes.
Looks like socializing and partying, correct?
Looks like socializing.
Maybe a small vacation.
I've never been on vacation with a big group of people like this.
Well, that doesn't look like what would you call that if that's not like a mini vacation?
A day at the beach?
A day at the beach. Okay, so maybe a day vacation.
Sure.
Okay. Let's look at the next photograph. Jay. May I approach, Your Honor?
Yes.
Oh, wait. We see it. Hang on. That's not a ton of people. You see the photo?
A little bit.
It's like 8 or 9 people at the beach. That doesn't look. Come on. Yeah, no, I'd remember that day.
May I approach, Your Honor?
Yes.
I do need to remind myself. That photograph looks a little older, correct?
They both look old to me. I don't know when they're from.
I'm going to ask you the same questions about that. These aren't true.
The fact that she's saying they look old to me and they're 10 years old makes me feel really damn old. So.
Trick questions. I don't want to waste your time. What's that from?
I don't remember specifically what or where this is.
Do you see yourself in that photograph?
I do.
You see Caitlin in that photograph?
I do.
You're all posing for the camera, correct?
Yes.
What's the location?
I don't know.
No idea.
I don't.
This is yet another socializing event with Caitlin that you can't recall.
I don't know where this is
Is that
exactly.
I'm sorry, I didn't mean to step on your words. Go ahead.
I don't know where this is exactly.
So you've had so many socializing events with Caitlin and other folks that you can't pinpoint this one as opposed to any of the others that you've had.
There you go. That's the
no,
question.
I'm saying I can't. These photos are old. I don't know. I don't remember where these were or the circumstances around them. That's what I'm saying.
You see how you're dressed in that photo?
Yes.
You see how you see the other friends that are there with you?
Yeah.
How many people would you estimate are in that photo?
Do you want me to count how many people?
Give me I don't have the photo in front of me, so just give me is it more than 5?
12
12 people.
ish.
Do you recognize those dozen people?
I do.
Did you go on a day trip with those dozen people?
Yeah, possibly.
When?
Possibly.
I don't
Come
know.
on, it's a
We're
photo.
sorry.
Of the
I don't
day
know.
trip.
I don't remember.
How many times have you gone on day trips with those dozen people?
I don't know.
How about turning back to photograph I? How many times have you gone on day trips and socialized with those number of people? Which looks like probably double that, 20 or 25 people.
I don't know.
That's a big group of friends of yours that includes Caitlin Albert, right?
A big group of mutual friends.
So It's not just that she's a mutual friend, she's a friend. Isn't that right?
Um,
Here we go.
as I said before, I would consider myself more of an acquaintance. We have mutual friends. I wouldn't consider her a close friend, but yeah, I mean that would be my answer.
You basically grew up with her, went to high school with her.
I didn't grow up with her. I went to high school with her.
When I say grow up with her, I mean you grew up in the same town as her, right?
Grew up in the same town.
Went to the same high school as she did.
Yes.
Socialized with the same friends as she did.
Yes.
Went on dates
Just-
trips with her,
Yes.
and have all the same friend group. Right?
I don't know that we have all the same friend group. These are people that we're both friends with.
But you don't consider her anything more than just an acquaintance.
I think I described it to you.
The answer to my question is you don't consider her to be anything more than an acquaintance.
I wouldn't consider her to be a close friend.
Now let's take a look at the last photograph.
One more photo. Come on.
Describe what's in that photograph.
It's a picture of me. Caitlin is in it, and there's seems to be other people in it as well.
May I approach?
Yes.
Both of you can take it. Sorry, I just want to drop it on you. That's a close-up photograph of who?
Caitlin, and I'm also in it.
And you're doing what in the photograph?
Isn't that a weird way of describing it? That's a close-up photograph of what? Caitlin, and I'm also in it. You know, not the logical way of saying, you know, a close-up photograph of me and Caitlin, or Caitlin and I. Caitlin and I'm also in it. It's a photo of two people.
As it relates to Caitlin.
It seems like I'm kind of kneeling down next to her.
Touching her?
Can I see that for just a minute, please? Thank you. I'm sorry, can you show me you? Okay, thank you.
So just for the record, and may I approach one more time? Your Honor?
Yes.
Thank you. Take a look at that one more time. You're sort of just behind Caitlin in that photograph.
Yes.
Caitlin's the one drinking the beer.
Yes.
You got your right arm around her.
Yes.
You both appear to be wearing swimwear,
Yes.
bathing suits,
Yes.
and you're giving some sort of a sign with your left hand.
No, I'm not.
Is that somebody else's hand that I saw? Maybe that's Caitlin's.
Yeah.
I'm sorry, I don't have the photograph in front of me. I don't have it committed to memory. Looks like that's a photograph that you and Caitlin posed for together, correct?
It seems like it's a close-up of a bigger, like a picture. It seems to be zoomed in on a group of people.
Which was posted on social media.
Okay.
Is that right?
Are you telling me that?
I'm asking you that. Have you ever seen that posted on social media?
I don't recall seeing this picture, but if it was on social media, then okay.
How long ago was that picture taken?
I don't know.
Who took the picture?
I don't know.
Where were you when the photograph was taken?
I don't know.
Probably at a beach if we're wearing bathing suits.
Probably at a beach or at a beach?
Well, I can't see a beach
I don't know. I don't know. I don't know. I don't
in
know.
the picture.
I don't know. I don't know. What do you know? Do we know much? So that was like 10 minutes of cross. And if you, do you know how much Jackson wishes the jury saw all of that? The jury comes back in, and we get to do it again in front of the jury. But I mean,
But you're saying she's learned.
she's learned. And the judge rules that you can't we can't introduce the photo. So right now he's really hampered on what he can say in front of the jury. Can't present the
And
photo.
that was based
can't
on the
show
Rule
photo.
14 violation? That's a problem.
I think so too. And all of those evasive answers, like that is the definition of evasive. I don't think it is a.
Oh, I
it's an
mean,
attorney's-
yeah.
I mean, that's an attorney's dream, right? You get someone on cross and they're that evasive. You're like, you want me to pull the teeth? Fine, I'll pull one at a time. Let's do it this way, one at a time. Oh, but that teeth pulling, the pain of that teeth pulling teaches witnesses in the future that, you know, maybe I'm not going to be that stubborn. She changes her tone. It pisses me off. Hey, Lady Lysandra, good to see you in the chat. Here we go again. Let me get the channel locked. I saw this question earlier. Philo, I always said that right. Who's the lady with the face mask thingy? Court reporter. I've been in a lot of courtrooms, but that's not something I've seen before. Yes, that is a court reporter. So sometimes the transcriptionists that do this, that has been, there are two fashions. One, the people that type or the stenographers, and now they have the people that speak audibly. They have dictation software and they dictate, they speak very quickly and dictate into the little, I call it duck mask. But yeah, that's the court reporter. It's just a different style of technology. Good question. Look how close the attorneys are to the witness stand. Oh, come on, get there.
So
There we go. Come on. Thanks, J. Michael RN. Steno mask.
And Rob, I hear you need more of this.
Yes.
You liked it enough to get through the bottle then.
Goes great with eggs.
Oh, I love it with eggs.
So
It's great.
jurors, from time to time, there are things that I need to discuss with the lawyers, as you saw. We try and do it as quickly as we can. It's in an effort to make sure that what you see and hear in this case is appropriate for you to see and hear. So sometimes we spend a little time now that will save us a lot of time.
I see the comments about this stuff. Why does it matter? Why does it matter? That's my question. Why are you being so evasive? If it's a photo from 10 years ago and if it's running in a friend circle, why are you being so evasive? Then just come out and say it. Answer the question. Don't dodge it 19 million different ways. When you dodge it 19 million different ways, I ask a lot more questions. That's the problem with it. Like, I get it. People are saying like it might not mean anything. I don't give a crap. All I know is that answer lit up 9 million red flags for me, and I'm going, why are you dodging this? If it's a photo from 10 years ago, a stupid photo, just say it. or you don't know, just, oh my God, why are you dodging?
Time later. So we do appreciate your patience.
May I, Your Honor?
Yes.
Thank you. Ms. McLaughlin, thank you for your patience. When we last left off, I was asking you about your relationship with Caitlin Albert. You recall that?
Yes.
I want to ask you a few more questions about that. You and Caitlin Albert have known each other for how long?
Since high school.
Which is,
See?
give me a span of time.
Correct.
So probably about 10 years.
You have traveled with Caitlin Albert and friends. When I say traveled, I don't mean to exotic locations. I mean day trips, etc.
Yes.
You have a group of mutual friends together, correct?
We have mutual friends. Correct.
Those mutual friends have gone on day trips with you and Caitlin Albert involved
Correct.
on more than one occasion, as a matter of fact.
Correct.
On many
Yeah, she's
occasions.
learned she doesn't want to ride this horse again.
Which sucks for Jackson. Like, this is like the wind in your sails just getting taken out. Like, he would have loved to pull those teeth in front of the jury.
True.
That's why I'm saying this he's pissed after this.
Many, I don't know.
More than 5?
I don't know.
More than 10?
I don't know.
You've seen photographs of you with Caitlin Albert on some of these day trips, correct?
Yes.
You've seen at least 3 of those photographs.
You see how he dodged introducing the photos or having to refer to them specifically? It's like, you've seen these. You have, in some fashion, at some time, seen these photos.
Yeah.
So it's a very skillful move. A lot of attorneys couldn't do that without getting objections and the judge yelling at you or instructing the jury.
And this
Yes.
judge is waiting
You're
to
friends with
obstruct the
Caitlin
jury.
Albert on social media?
Yes.
Other than the 3 photographs that you've seen, we just talked about, there have been other events that you've been at with Caitlin Albert that weren't necessarily photographed, or we don't have those photographs, correct?
Probably.
Oh,
You know that Caitlin Albert is the same.
I didn't catch that one before. He basically just had her testify that there's probably a lot more photos, or there's more photos out there. Interesting. Okay.
Caitlin Albert. that's
I always
daughter
like the
Brian
way of
Colwell.
asking it, just of like, are there any more photos of you? Because then she doesn't know, right? And
Yeah.
then, yeah.
Yeah. Huh.
As you sit here.
Yes. As I sit here today, yes.
And you know that Caitlin Albert also has siblings, Brian Albert Jr., correct?
As I sit here today, yes, I know that.
And you also know,
And now that answer makes my perk my ears up. As I sit here today, like, why did you clarify that? Like, why did you feel the need to clarify that?
as you sit here today, that 34 Fairview was, at the time of January 29th, 2022, the Albert home, correct?
I know that as of today.
You indicated, well, let me rephrase that. When you showed up at 34 Fairview that morning, did you recognize that address or recognize the home as being that of Caitlin Albert's?
No.
You have since learned that that was Caitlin Albert's home.
As I know that now.
And you gave your original statement to Trooper Proctor the next day.
Yes.
And from that day to this day, or let's take yesterday, from that day to yesterday, you learned that 34 Fairview was the Canton Albert family home, correct?
You're asking if I know from,
Between those 2 dates,
yes.
between the time you spoke with
Yes.
Proctor in this report till yesterday when you testified, you now know that that's the Albert home.
Yes.
And you also indicated that between that report that you gave to Trooper Proctor, that statement that you gave to Trooper Proctor, and yesterday's testimony, your statement has evolved. You've already admitted that, correct?
I don't think I agreed with you on that.
You did.
It's changed. It's different.
I've always testified to I feel as though my testimony has been consistent.
I appreciate how you might feel. I'm just interested in the actual facts. You didn't tell
That was solid burn.
Trooper Proctor anything about this officer questioning my client. Correct?
Objection.
So I'm going to see counsel at sidebar because I think this morphed into a different.
Yep, he's taken a different path, and it's like, where are you going? I kind of want to see where you're going because I don't want you getting into the areas that people. So I wanted to pull this question up, and this is something I do get it, but do those photos pertain to the death? No, they don't. They absolutely don't. But why is she evading the question?
Because
That's my question.
she doesn't want to testify, or she doesn't want to give anything useful to the defense.
And right now we're in the prosecution's case in chief. So the defense gets to present their evidence, and arguably or ostensibly you would think that the defense is going to present some evidence to connect some of these dots. But what they're doing is they're signposting a massive question mark, and they're saying, here's the big question. And yes, these photos might not mean anything to you right now, but I want you to think about, why am I asking these questions? Because I'm going to bring that back later. So it was she did a lot more harm to herself than good by resisting. Unless there's some there. I don't know. Now we have to get this last question and that's the end of it. Just how many minutes?
Hot sauce.
A couple of other questions. When you did make this statement to Trooper Proctor, your visit to Canton PD was coordinated by another officer. So
Okay.
put you and Trooper Proctor together for the interview, correct?
I don't recall that.
Do you recall being
Question is, who set up the interview with Trooper Proctor? Who coordinated for you to speak with the trooper and give that written statement, or give the statement that he wrote down? The one that said, I hit her, right?
contacted by a completely different officer to say, hey, Trooper Proctor wants to talk to you. Come on into Canton PD. Let's have an interview.
I don't remember exactly how the interview was set up.
So that was my next question. You may have just told me this. Do you have any recollection who set that interview up?
I don't.
His name Kevin Albert sound familiar?
No,
You know Kevin Albert?
no,
You know him to be a police officer at Canton PD?
no,
You know him to be the brother of Brian Albert?
Objection.
no.
The objection sustained.
Ruh-roh.
That's all I have, Your Honor.
Okay.
And that's all I needed. So that's where I'm going to stop on the Karen Reed case, because you're going to do a recap, and I imagine you're going to watch the rest of that stream. And it was the Caitlin.
I got to
Albert.
go through it and timestamp and all of that fun stuff. It's a process.
It's the Caitlin Albert who I went. Listen to how it began. I went to a high school with someone named Caitlin Albert. How it ended. Like we went on. These trips
I mean,
and
you just
everything.
knew it was crap, right?
I mean, it was, oh God. Pulling teeth and doing that and being that evasive. You know, he would have, if she would have said in response to, did you know someone named Caitlin Albert? Yeah, I went to high school with her. She was a friend of mine.
Yeah.
Okay.
Just be honest. The other thing is, like, she really ought to have no skin in the game here. She really shouldn't have anything riding on this. because the only way she ends up going in cells is if she bullshits, like if she lies in court. So just like, I mean, assuming that that it wouldn't be like a situation of like, you should be pleading the fifth now, of like, yeah, I know her. We totally conspired to, whatever. Assuming that's not what's going on, then really it's just like, just answer the freaking question. Yeah, I know this person. And you could say like, we're acquaintances, but we go to a lot of the same things is also a much better answer. Like, because there's a lot of people who I see at like various events that I'm not friends with, but you could find me in a whole bunch of pictures with. And the thing is she could have gone to that easily. Like, yeah, we're acquaintances. And it's like, do you know this picture? Yeah, okay. We were, there's a bunch of us in a picture.
Or
No shit.
you know what? Be ready for the answer to basically say, yeah, she's best friends with that person who was my best friend. We went on the trip together.
Yeah, like that's not But I mean, assuming that any of these things are true, that it's really easy to, it's really easy to deal with these things. You just tell the freaking truth. It's not that hard. And yeah, I don't get it. I really don't.
And that's people have asked the question. I've seen it repeatedly. What incentive do the paramedics and anyone else have to lie? And I said, I don't know. Arguably none. I have no clue. They don't have that incentive. Arguably, but why are they testifying this way? Why is it this evasive? Like, I don't have to know what reason why they're doing it. I'm asking, why does this come off this way? Like, yes, it's a small town. I understand that. You probably all know each other. I understand that too. Families probably get along with fine. What the hell? What was that? What was that shitstorm that we just saw? Oh. Yeah. Well, that was something. That was fun. So that was the highlight of my day was going, why are you being so evasive?
Also, Rob, there's a thing on Twitter that's happening right now with people posting their channel demographics for gender. I'm curious as to where yours land these days.
I can tell you. Hang on.
I just pulled mine up, and it is 50.3% female, 49.0% male, 0.7% user specified, which for a channel that talks a lot about guns is insane, because usually they're at like 97% dudes. So,
well, you really want to know the answer?
Are you at like 90.7% women?
Let's see. Last 28 days, the views, 85.3% female. Let's see lifespan of the audience and who's watching. Lifespan of the audience, full life of the channel, 78.3%.
How do I pill it to light? Oh, there we go. Lifetime. Lifetime, I'm at 58% male.
Yeah, I'm at 78.3% female, 21.6% male, 0.1% user specified. So, but again, I have no problem with that. I love that all these people, all these smart ladies and gents in the chat.
Oh, absolutely. I was just astounded that it's like basically a 50-50 split. That's insane.
Yeah.
That never happens.
Yeah, doesn't. All right, swoop to questions. Okay, let's catch up on the Karen Reed related things. Let me go through here. Oh my gosh, there's a lot. People have a lot of opinions about it. That's the thing. People have a lot of opinions about this trial. Tons of opinions. So, K-Rab, her current lawyer was, quote, hired by Depp, her friend, when AH sued him. He claims he beat them in court 2 days after filing. In fact, JD got AH to drop it. I didn't know that. I've been impressed with defense counsel, both of them. Chelsea, today Lolly's rephrased a what if any question to a what sort of question. My mind was blown. I know. I heard the what if any twice in one question. It was pretty bad. J. Michael RN, yay, joining from home for the first time. No more working Friday nights. Congratulations, my friend. Glad to have you tuning in from home and not from work. Jenny C, did you know the EMTs have to get recertified every 2 years? I know everything I need to know about EMTs for the rest of my life. I don't need to know anymore. Melanie Paré, my favorite part from today was who, if anyone, was driving the ambulance? Sir. P.S. Belated birthday gift coming your way next week. And don't you dare say I shouldn't have. I made you something. Well, making something, thank you. You told me not to tell you I shouldn't have. Still going to say you shouldn't have. Thank you. Charlie Raven, love the bromance more and more all the time. Me too. The world wonders. I've been in an even weirder courtroom. The judge was in the corner between counsel tables and he was lower pitch shaped like a tiny baseball diamond. That's really weird. That takes calling balls and strikes to a new meaning. Trace Fagan, I feel bad for the women of Massachusetts because they have trouble with inches. Oh my. That was a comment. The world wonders.
I made that joke on my last recap.
Did you?
Yeah. I was like, they keep saying like 6 inches and it looks more like 4 inches. So that's
terrible. The world wonders. Correction, the council tables were partially on a tiered floor and the gallery above and behind, all in a pretty small room. Super weird. Yeah, I don't like that. That seems odd to me. Aurora W, thank you. I'm not a fan yet of the judge, but for local flavor, Massachusetts and Maine don't take any outsiders well. Note judge softened with the Boston attorney. The side bar is an interesting thing. I will fail at every Boston accent, and God bless if you are a court reporter that gets tasked with going from like the DC area or the South. If you're like a court reporter that's trained like in South Carolina and you get sent up to Massachusetts to transcribe a trial, good luck. Good luck. Yellow Pill, ma'am, where did you see each other? At someone's house, a church, with the whole town, at the club? I don't know. I have a lot of questions. Melissa Smith, the judge, Bev, I will allow a third-party culprit defense. However, I will not allow any evidence to support that defense. Clever girl. Right now, you don't get to put on that affirmative defense. I mean, you can start to lay foundation for it, but you get your case in chief. So they get the chance to start laying a foundation for that. Lady Los Angeles, she's the one who said that Baron Reed did it. Yes. That was the witness. Sir Merrick, Ian's derision anytime the blizzard is brought up is why you need a local jury. Yeah, that's... Yep.
fair.
Just because I graduated high school in June of 2004, class of 150 students, I might not know everyone's name, but I could probably tell you where a pic of me was from with a person or group. To be frank, I'm a square. You could point to a picture of me in high school, and I could tell you in high school I graduated 02.
I mean, I might not be able to tell you when and where exactly.
I could give you a ballpark.
And I could probably tell you like from the background that was probably because like there's some people I've hung out with a whole bunch, right? So I could probably be like, yeah, I couldn't tell you what year, but it looks like we're at the Sherlock's pub. Like that was a place I hung out with with friends. So
you mean to say that you would know something about the photo?
Yeah, I mean, you could at least reassemble something from your,
correct, without speculating. Like you can give a ballpark answer truthfully, factually, without speculating. Yeah. So I just
I
did
mean, you
not
could say like,
understand
I don't
basic-
know for certain, but I could tell you that that's this beach. I go there a bunch, right? Because yeah.
Sarah says, so she remembers not being on a vacation with the people in the picture, but doesn't remember the picture. Okay. Raven254, thanks for the gifted memberships. Much appreciated. Thanks for growing the channel. Philip Martin, 10 minutes to say they hung out some, but not a lot. Yeah. And my question is, why did it take 10 minutes? Why did you make the attorney pull the teeth? Mispronounced name, fantastic username, by the way. Could mean that Caitlin's such a non-friend that the trip was irrelevant. Hence, she doesn't recall. Caitlin planned the trip. A mutual did the inviting. That doesn't hold water to me. Like, I don't, even people that plan a trip that I have no connection with, if you show me a photo and I'm in it, I can probably remember at least a little bit of details. It's the evasiveness. That's my question. Just why? Oh, Susan. Or oh, Sussan. Love you and Runkle on stream together. Did you catch when the prosecutor asked who, if anyone, was driving the ambulance? I did. It was good. There was a lot of, I think we're at 301. 301, what if any? 301. That is 301 too many. Free Divine Spirit, Runkle, you got it. He's the weasel of every kind. Shauna Everett, as a juror, her evasive answers would make me question all her truthfulness or at least the reliability of her memory. But the jury didn't see all of that evasiveness. They only saw part of it because that's what happens with that voir dire. Takes the wind out of the sails. Melissa Smith, she asked Proctor if she would get in trouble for lying on the stand, and he said, nope. I don't know. Proctor's going to be an interesting witness. J. Michael R.N., thank you for the very generous super chat. This is critical. She's the one who said she heard the confession. Yes. She said everyone else heard it from her. She did. She testified today that she opened the ambulance door and she relayed the information.
Except
Then
a bunch of people testified they heard it from her directly.
Thank you.
So that is frustrating.
And now I'm going, why are they saying that? So I don't know reasons why they're doing these things, but the testimony, that's sworn testimony, isn't lining up. Now the homeowner's kids is her friend, and the homeowner's brother set up the interview. That's the implication that's being drawn and being brought out by the testimony. Melanie Party, you should have Spidey analyze this on a live. Interesting. I'll send him the link. Sarah Noble C. Big thanks to whomever likened Judge Bev to Lumberg. And kudos to Rob and Ian for this evening's shenanigans. Thank you, Sarah. Anna, I understand wanting to believe the judge is unbiased, but during a pretrial hearing, she basically suggested to the pros they should call Proctor. They shouldn't call Proctor. Prosecution, they shouldn't call Proctor.
I mean, the thing is, from what I heard, she basically said, defense, if they don't call Proctor, are you going to?
Yes.
And the thing is, I've had judges make suggestions like that, and sometimes that suggestion is not necessarily indicating that they're on the prosecution's side.
Correct.
Like, I had one where after there were like 5 officers, and all of the officers basically, and the judge had a bit of a roadmap because in Canada, when we're when you want to argue that someone's rights have been violated, you have to file something called a charter notice, which basically says, I am going to argue that my client's rights were violated at this trial. And so the judge gets to see that and is kind of aware of where you're going. And so I had 4 officers out of 5 who were involved testify, and I kind of pinned them down to the same version of things, which it wasn't directly pointing the finger at the 5th officer, but it was suggesting some problems. It was basically
they're kind of going, I'm not saying who did it. I'm just
basically, my client ends up with like a bruise on his face, and they all agree that it happens in this time frame where he's alone with this other officer. And they agree that this other officer was particularly upset for reasons that if I give them will be too specific, so I'm going to leave them out. But basically 4 out of 5 officers say this guy like had a moment where he was alone with this guy, and then when the guy comes back, he's got a bruise. And the judge is like, Crown, do you think it's a good idea to call officer number 5? And the Crown is like, I'm going to talk to my friend. And came back with what was a very favorable deal. So that was the end of the file, right? That was, the question of like, you're not going to call this officer, right? Was not telling the Crown, hey, I think that your case is fantastic. It was in fact the opposite. It was like, do you really want to get your officer up here to make things worse by lying on my stand? Because I think that's what's going to happen. So, and the Crown quite reasonably figured we have a problem here. So, yeah, I can see that, right? I can see that either way. So without actually watching,
I've had a judge basically say, like, judges will do this. They'll say, "Do you really want to do that? Is that what you want to do? Because that's a decision."
Yep, that's the thing. Is sometimes you can get a judge who's like giving hints out, and it's like I don't necessarily like the hints.
So the other part was, remember how I told you, and you need to pull this up on your stream, the testimony about the jacket and how it wasn't torn. Right?
Yeah.
Had no tears. Those are the injuries. Those are the scratches to the arm. Now, when I thought about it, I thought
Where's
about
that
like if I
screenshot
take
from?
that it was for, I think, for one of the pre-trial hearings.
Okay.
But they showed that to the jury today. That's the same photo. But what I thought of was, you take if you take like a pen or something sharp to like a shirt, you can move it with the shirt and scratch the skin underneath without tearing the shirt, right? You can get a laceration through clothing. And that was what I thought when the testimony was being presented. But then I saw the photos going, that's a little different. I would expect some tears to the clothes. Now, we don't have testimony yet. But I would expect the prosecutors to connect those dots. And they might. We'd have no clue. Okay.
And
Chase
have
Collins?
a glance at
I saw it.
the back end. Good.
I saw it. Chase Collins, so many stacks of ladies. There's a bunch in the chat. There are. Jen V. Oh my gosh, that's my husband. LOL. He calls me the house wizard, as I usually can remember where he left his stuff. We're both ADD. Oh, that's with regard to the cleaning.
I feel bad sometimes because sometimes I will, I'll ask Mrs. Runkle, I'm like, where is this thing? And she's like, did you look in obvious place? And I'm like, I thought I did. And it'll turn out it's like behind the milk or something, but it's like, oh, right. So as an example, I was telling Mrs. Runkle that I was sad because I thought this was the last of my nuclear beans.
Okay.
And you can see there's like 4 beans left and 2 Carolina Reapers in this jar. And she's like, I don't think that's the last of your nuclear beans unless you ate a lot more of them than I thought. And I was like, it is though. She's like, did you look in the box with the pickles? I went, why would they be there? And of course it's because she consolidated jars into one box, because why have 2 boxes that are partially full when you could have one box that's just full? And I was like, this makes perfect sense. And no, I hadn't looked in the obvious place. And anyway, the good news is I have a whole lot more nuclear beans than I thought I did. So
see, learning is fun. KL Burke, Bowzalay, thank you for correcting my pronunciation. Yes, I'm that a-hole. That's not an a-hole move. That's a corrected pronunciation. I appreciate it. Debbie,
if I ever become a judge, one of the things I'm going to do with my decisions every witness or party name is going to be
Phonetically
phonetically spelled out. And I don't care if it's like Mr. Rogers. It'll be like, Rogers in the thing. Because it's like, we're spelling out everything. Because if it is like 2057 and pronunciations have changed, I want them to be able to get it right. Because I hate when I'm reading case law and I'm like, I don't know how to do this one.
I know. It's
Especially
terrible.
because on one occasion I read a case about a guy, and the guy in the case was a bit of an a-hole, but he reached out to insult me for the coverage of the case, B, to tell me to talk to his lawyer to get a better accounting of it, and C, to mock me for getting the pronunciation of his name right. And I was like, I feel bad about one of these things.
Yeah, it's the last one.
It's the last one. Yeah. So,
Debbie W, thank you. Got my tickets for Metallica in August in Seattle. Oh, yeah. I'm super excited and a happy metalhead tonight. Best anniversary present from my hubby ever for our 16th. Congratulations. Happy 16th anniversary. That's awesome.
I think Metallica is coming to Edmonton, and I meant to get tickets, and then I ADHD'd. So I got to see if those are still available.
That'll happen. John Hanna, thank you very much. Rob once struggled to say a legal term, inspiring this haiku as a definition. Alas, it won't help at all with the pronunciation. Extrajudicial. One more lawyer than you need, but she's a pro boner. Oh, God, she's a pro boner. That's, yeah. Walked into that. Just read that right out loud. But I screwed up. I was trying to be cocky. Extrajudicial.
So Edmonton, Alberta, there is a show, Metallica, 2 nights, 2 different sets, 2 different opening acts. Metallica, Pantera, Mammoth, 5 Finger Death Punch, and Ice 9 Kills.
Okay.
I might have to book that right now.
You do that.
Except it doesn't like my VPN. We'll just
recovery addict Scott coming in with spicy maple bourbon pickle juice. That sounds delicious, to be honest.
Maple pickle?
Yeah, that sounds delicious. Megan Runzer, you have to try a tequila pickleback. It's delicious. I have. It is. Cat P, will you cover the new Darryl Brooks trial Monday? I will unfortunately not, but that sounds like pigeon business that might be up Ian's alley.
Wait, what's the new trial?
No clue. You can look it up. Chris M96 will be. Go ahead.
I'm trying to pick out tickets now. It's like I don't know.
You do tickets. I'll remind you of Darryl Brooks. Hey,
fair.
Kristen, will we get a goodbye shop members only shop stream? Yeah, I will have to do members only before the shop gets shut down for moving. Chrissy Lee, I'm sorry I go MIA often, but you're here. I'm glad you're here, Chrissy. Thanks for being here. Don't apologize for going MIA. Take care of you. Deb N, thanks for all you do, Rob. You're the best. Thank you very much, Deb. Amanda Wagstaff's been a member for 13 months, over a year and counting. I'm your Huckleberry. Hey, Rob, just checking to see if you got your package. I have to double check. I have things to open, but there are boxes that I am packing, which is why the jury bots are gone. They're packed away to go to the new house. So I'm trying not to open boxes for risk of losing the things and the things I'm packing. Joy W101, just keep in mind while you're moving, that'll help. It does every day. Emily Aarons, drinking brown sugar milk boba tea in Wisconsin. That sounds interesting. Never had it, but I'll take your word for it. Katrina Turner, dew and welding torch. I don't know what I'm making yet. Hopefully something cool. Lindsay, what if any sort of snow may have been present on your route to obtaining your paramedic certifications, if any may or may not be required for your current or past position at the Canton Fire Department? Yeah, that sounds about right. Jenny, thank you for being a member for 10 months, almost a year here with y'all. Thank you. Phoenix, hello, Robin chat. I got a new puppy. Good luck and congrats. Just because getting over day 8 of my first multi-day migraine with water after some iced tea should be done soon. I hope so as well. I hope it's done now. Mary Kay, happy belated birthday. Thank you very much. Baby Steps, thank you for the gifted memberships. Equality, always so nice to hang out with you guys. Thank you very much, Equality. Just because, thank you for the gifted memberships. Canonical Heat, gifted memberships. Thank you very kindly. Henhouse Bath Company. Yes, I did. It's sitting on the counter. Just to be dandy, what did you think of the damage to the car? I'm going to let Ian talk about that when he does his recap. Ian, when you do your recap, reminder, look at the jury view. The jury view, there was media that was 100 yards back, but we're getting zoomed in shots of what they were looking at, which included the Lexus.
Oh, that I'm really interested in because.
Oh, yeah.
Yeah.
Opposite of Nisha, I started with no knowledge. At this time, her lawyer said, quote, she was framed, and I rolled my eyes out of my head, but I'm starting to believe her. I'm just starting to have questions. That's where I am. Tracy Collins, thoughts on the furrows, arm scratches, pics, now that you've seen it? I have a lot of questions. That part, the ME there better be explanations for that.
I look at those.
How does snow do that? How does a car do that? I don't understand.
That's the thing, is I find it very difficult to imagine. The thing is that they also don't look super like a cop, like a police dog set of bites. That looks
they
more
don't look like it. No, they don't. They look like
that looks more like
cuts, like glass, like a bottle, like a glass bottle.
Or
road rash,
civilian dogs versus police dogs, if that makes sense. Because like police dogs are trained to grab
and not let go
and dig, right? So I don't think it's a bite. Or I don't think it's a police dog bite, but people have noted that this was a failed out dog. Because like, I wish I could show you the pictures because they're horrific. And I can't show you for two reasons. One, they're like from case files. And two, YouTube would nuke your channel from orbit if I tried to show that.
Yeah, don't do that.
But they'll like grab and pull. And so when I was an articling student, I had a file where a guy was improperly bitten by a police dog.
Okay.
And that image makes me wish that I had like Emily's level of aphantasia, because I can still see that in my head.
Yeah.
And what you've got is a hospital photo where you can see like the dog bite, and you can see where the teeth grab and like pull flesh away.
You don't need to describe it that thoroughly.
And you can see dog teeth marks in bone.
Yes.
So that's not what we're looking at here, right? That is, that's a very different kind of injury. This looks more like dog that has not been taught to do that will like grab and bite and let go, right? Or maybe claw marks. But it doesn't look like a police dog, if that makes sense. So
that's my question.
I just, yeah, and it definitely does not look like a car to me. Because, I mean, one of the things about doing criminal defense, you see a lot of pictures of injuries. I've seen stab wounds. I've seen gunshot wounds. I've seen wounds with a literal ice axe. I've seen, all sorts of things, right? Anything you could think of. I mean, I haven't seen what an injury from this thing would look like, but just about.
You can imagine it.
Lots of other things. You see like what those injuries look like. And, so I'm just like, this doesn't look like police car, or like, this doesn't look like car. It doesn't look like police dog to me. What I'm thinking, like the theorizing I get in my head is guy gets into a fight at the house, like at the party. Dog intercedes because that'll happen, right? If you have a dog and you start throwing hands with somebody in your house, the dog is probably going to bite the other person. Because, like,
in theory, yeah.
Well, so we used to have this German Shepherd mutt called Paddington Bear. Paddington was an absolute sweetheart, loved every human being on the planet, absolutely lovely person. I have only seen Paddington go aggro once. And that was, there was a guy who came to the door and was trying to run a scam. And my wife ran into this guy who was trying to, the scam is basically they try to get you to agree to sign over your power, your like electric bill to them. And they promise it's going to be cheaper, but they don't actually get you to agree to do it. What they get you to do is they get you to show you your electrical bill.
Yeah.
And then they take the information off that and they fill out the form to change your registration.
Yeah.
So I was like, I'm sitting there and I just hear Paddington go, and he is like in full on growl mode. He's like, I want to kill this guy. And I get up and I'm like, I got to see what's happening because this is unheard of. And Mrs. Runkle is like, can you handle this guy at the door? Because I am getting a real sus vibe from him. And so I go up, and once I'm there, I'm like, this is a scam. And so I tell him as much. I'm like, we're not interested. This is a scam. We know it's a scam. Goodbye. And at that point, he threatened that he first threatened that he was going to wait on my porch. And I was like, you wait as long as you want. And then he threatened that he was going to break my window and come in through the door.
Good idea.
And I said, okay, I'm closing the door. That's not going to go very well. And once I closed the door, I made a very distinctive noise from behind the door.
Mm-hmm. I know the noise.
Anyway, he decided he did not want to come through our window and he left. But I was like, the thing is if he had come through the window, I wouldn't have needed to use the shotgun. Paddington Bear and Ripley, which was the other dog, would have torn him to pieces as he was stepping through the glass. And like, we would have just had to skip their dinner that day. So, those dogs were both absolute sweethearts, absolute lovely sweetheart dogs. And for the people who are saying like, what is like, they love the name Paddington Bear. My wife and I trade off on naming the dogs. So I named Ripley. She named Paddington Bear. I named Zora. She named Potter. So the next dog I get to name.
Dare we ask?
I haven't figured it out yet. I didn't know Zora's name. Like, I didn't know what she was going to be called until we literally went and picked her up from the rescue. And I was driving back with her. And I started out that drive not knowing her name. I got to the house and I knew what her name was. It was just like,
you have officially started 4 stories and finished none of them. So I need to get us back.
I'm sorry.
On a wayward track.
I'm sorry.
Like just, but I love the start of all 4 stories. They were great. Oh no. That's a sign that I need to speed up on my last coverage. Oh my gosh. John Common, I saw your super chat. I forgot. I pulled it down really quick. I think it was something about the witness and some relationship with the other one. I'm sorry. I have no clue, but it is what it is. Shelby Taylor, this was fun. Really enjoyed trialing with you guys. Thank you. Chrissy Lee, as a woman in Massachusetts, I can confirm the inch is problem considering I'm only 4'10" in height. Also, since it's my neck of the woods, let me know if you could help you both in any way. I think you just watching the coverage is great. Thanks for being here, Chrissy. Tracy Collins, thank you. I would have asked a multitude of questions. Have her sell. use their pool. Dogs sit Chloe. I mean,
The
you
thing
can't
is you don't ask those questions unless you can pin her down on a wrong
Correct.
answer.
Yeah.
So if you have something where she was on Facebook saying dog sitting Chloe for my best buds, you're like, then you can ask the question. And then when she says, no, I've never dog sat for them, you're like, isn't this your Facebook where you said dog sitting Chloe for my bestest friends ever? Yeah.
Yeah. At least Charlene, fine art memory is different for all people. I remembered back my preschool days, but I can't remember. Freaks them out. I'm in my 50s. It's possible. I don't know. Line at heart, my cat got extra treats tonight thanks to Ian's bag crinkling. So this super chat is really from Jackson, my cat, not defense attorney. Thank you. Light Queen, I don't understand how no one who supposedly heard her say I hit him never tried to get her to clarify how she hit him. There's a lot of questions that I have curiosity about, but it's all up for argument at the end. LJ Peach, the so-called acquaintance comes from a powerful family, and the dead cop was at a party at the home of the family. I know the basic storyline. I'm just watching the evidence as it's being presented and trying to follow the trial in that fashion. Tiffany Zbarek, Proctor has, I'm sorry for butchering the name. Proctor has a lawyer. If you were them, what would you tell him to do? Is it legal for him to plead the fifth? Not with regard to every question. Like you can, yeah.
Important question for advising Proctor's, Proctor. Is he a French citizen? Like a citizen of France?
Why?
Because if he has citizenship in France, I would probably advise him to go to France and just stay there.
Terrible. Oh God, terrible. He can't plead the fifth to every question. He can only plead the fifth to things that implicate criminal behavior and conduct. And not everything he did in the course of the investigation is criminal in nature. Plus, I'm not sure
people saying why France? Because France doesn't extradite their citizens.
You know what? I got to think about that more, Tiffany. Let me think about that more. Because a lot of what he was doing was in an official government capacity. I don't know if that's available. I don't know. Let me think about that. That's a good question, though. It's a very good question, honestly. Regardless of how bad it looks, and if it does, if he does, is all evidence not in, if only able to establish through him? No. The evidence can, a lot of the evidence can still come in, but I need to answer that first question. I need to look that up. I hadn't thought about that. Sandy, thank you for the gifted memberships. Very much appreciated. Malsey66, Judge Bev's bias here is so obvious that she's acting as though she's a second chair for the Commonwealth, or first when Lolly can't do his job. You don't teach the jury the law, you instruct them. There's both. That instruction the judge gave on what is or is not evidence is completely proper. That is completely fair game. And honestly,
the thing is, she did a lot more gently than she could have. She had license to rip into them because the defense asked several questions that they knew were improper. That one question about did anyone else have a dead cop on their front lawn?
Or and if I ask you again in 2 weeks, it'll change again. Oh my God. Those,
The judge could very specifically have gone into defense counsel has asked a number of questions that are improper, and you are to disregard them. And I have told defense counsel not to she could bollock out defense counsel in front of the jury a bit for that. She can't go too far, but she could have gone farther than she did. She was very gentle about that. And
that's not where I have concerns with her. Not on that stuff. I think her jury handling is fine. I don't like how quick she is it feels like the questions that she's sustaining objections on are proper, and I have questions as to why. They probably know the answer. I don't, because I'm not privy to those discussions. Debbie W, I'm going to both nights in Seattle, Ian. Oh, that's awesome. Both
Oh,
nights?
that is
fun.
cool.
Caitlin Moore,
Mrs.
best
Runkle
concert.
only wants to go to one night, so I'm trying to see if I might have another friend to join me on the other night because there's 2 nights. So, yeah, I got to figure all that out.
Caitlin Moore, best concert, TWRP, a retro futuristic funk band. Cool. Dark Ferenz for Zero. Darkfire Zero, thanks for becoming a member. Tracy Collins, teeth on elbow, paws on each side. Look again. I'm waiting for the ME. I want the ME to pull that photo up in big screen, and I want the ME to explain what he sees, and I want the cross-examination on that. Like I'm saying, this trial is going to come to us. I'm just letting it happen. Mostly harmless fuzzball. I started this one, Ian. Robin Ian, Darrell Brooks is going to trial for charges on witness intimidation, intimidating a victim, and bail jumping, which took place in Milwaukee County. Ooh, that might be interesting, Ian. Witness intimidation, intimidating a victim, and bail jumping.
It might be. And I did chat a solid favor as I muted before I shook the treat bag.
I saw you. Just Sarah, and the injuries don't look old to me either. They didn't. Like I said, I mean, it's going to be interesting. Google O'Keefe versus Georgia dog bite, identical. Interesting. Happy at heart. I wonder why defense never asked her if she was underage and drinking, or was she 21? Because it right there, that would be essentially an improper attempt to impeach a witness for something that's a collateral issue. Like, you got her to lie. You got her to evade the question. You got her to be deceptive. You can impeach her, but you can't go down a road of proving that she was doing something else unlawful that has no correlation to this. LJ Peach, Mark Furman pled the fifth also. Interesting. I need to look this issue up. I don't know if he can. I need to look that up. Then an argument fight that went too far is likely. I don't know yet. Tiffany Zabranick. I think I got it better that time. Ari Proctor, he's under investigation, perhaps. FBI indictment and civil exposure? I don't know. Can they read the grand jury transcript? That would be a no. That would violate confrontation clause. Can't do that. And all he said, you'll hear from Proctor.
Unless some possibilities of, I mean, you can get some weird circumstances, like if Proctor dies, maybe.
Even then, I think that violates, that might violate, because grand jury, keep in mind, grand jury, defendant's not present.
I think the defense would have a better argument for bringing in his bringing in his
the defense could bring it in, but the prosecution can't.
Yeah, I think, yeah.
Yeah, and the reason, let me explain why. So if Sixth Amendment gives you the right to confront the individuals testifying against you, which means that they have to present testimony and give you the opportunity to combat that testimony directly to them. That is a right that belongs to the defendant, not to the state, the defendant. So under that circumstance, the state cannot bring in a transcript or a video of somebody that's not there to testify, or it's testimonial nature, because you can't confront that testimony because they're not there. There are certain exceptions for cases where, you had the opportunity at that point in time to cross-examine them. That's one exception. But that's why they can't bring in the transcript for the state. Now, the defense, they can bring it in because the state doesn't have that right. Jen K, landed in. Y'all are still going. Thanks for F&F. Thank you very much, Jen K. Carson Pratt, what the Karen Reed trial and Canton PD need is an intervention like from Jane, the man they call Jane. Hey,
Tiffany, you get that reference, right?
No, I do not.
You watched Firefly, right?
Yes.
So you know the episode where he's like, we need to go to the crappy little town where I'm a hero. You remember that episode?
Oh, yeah. Okay.
That's called Canton.
Okay.
The town is Canton. So
now I get it. All right.
Jamestown is Canton.
I got it right the last time, Tiffany. Thank you. Thanks for the correction. I appreciate the phonetics. Okay. So we're going to go speedy through the beginning of the Kohberger thing. Oh my.
I don't know that speedy is in my wheelhouse.
We're gonna try. And I'm gonna be pulling up chats along the way. Because it is midnight. Happy Star Wars Day to everybody. But I have been accused of putting topics on the docket and not getting to them. Don't not going to be accused of that anymore. So, Rob, how would you handle a judge who was sighing passive aggressive? I would ask the question. I would pause and say, "I'm sorry, Your Honor. Was that a question?" I would probably say, "Was there?" Like I'd interrupt that. I'd make it kind of clear, and then I
put on the record just like I'd just be like, if we could excuse the jury,
yeah,
and then just be like, Judge, I just want to raise that you've been sighing audibly, and it may distract the trier of fact from the issues at this case. So I just wanted to put that on the record.
You basically say, I'm not arguing it was intentional, but
yeah. But if you could be more cautious with the microphone, and although in Canada the microphones do not amplify, at least not where I am. So, but you could just say, like, if you could be more cautious, I think the jury may be seeing this, and I don't want this to become a trial issue.
Or you basically just said, Judge, and it's this isn't me making a comment as to you. It's I have an obligation to preserve the record, and if I don't raise it, I can't. It's the attorney that comes after me is going to call me ineffective assistance of counsel. So, Shiraz, hi Rob, I'd love to go to law school at 58 years old, but don't want to actually practice. Reasons: what would you do in my pants? Go to law school.
How much do you love it? Because law school is expensive. And it sucks. And the thing is, for every class you love in law school, you're going to have to take a class that sucks.
Yeah.
I had to take property law, and no shade on my property law instructor, but property law is when you will learn things like the rule against perpetuities, which is basically,
but yeah,
it's basically the learning equivalent of doing a line of this stuff.
It's not that bad.
It kind of is, although I was one of the few people to actually correctly articulate the rule against perpetuities and correctly apply it on the exam. So
I booked Will's Trusted Estates. I got the highest grade in school.
It's, but the thing is there's a lot of stuff that you'll have to learn that just sucks. Like, I took a class on maritime law, and you know what? It was actually pretty interesting, but I can tell you that a lot of people would look at that maritime law class and just be like, are you kidding?
You know what, Shiraz, go to lectures. Just find people that are speaking in your area.
The other thing is, technically, in order to sit in on a class for the whole thing, you have to pay to audit it. However,
I didn't mean that. I meant like schools will have guest speakers all the time.
If you actually, if you send an email to a prof and you say, I would love to sit on one of your classes, just say, I'm a 58-year-old, whatever it is you do, right? 58-year-old mechanic. I have never really had any law stuff, but I would like to I'd like to learn a little bit more. Would it be okay if I start, or if I if I take your class, if I sit in on your class? A lot of profs will be like, you know what, you're welcome to do so.
Mm-hmm.
So yeah,
it's a good option. I don't disagree with that. Reach out. Mozzie 66, the judge in her opening of the jury said, "It's my job to teach you the law. Isn't it correct to say instruct?" I don't see an issue with that. That's fine either way. There's really no problem there. Okay.
Instruct versus teach.
Almost
jury instructions are typically sort of graded on appeal on sort of a functional basis, not on a technical one. So, if they use instruct versus teach, that's not going to be a big issue. Typically, what it's going to be is if they actually teach you wrong in some way. Did they actually, did they provide the wrong info in a way that will cause problems? So, if they did that, then that's an issue. But I mean, I'm not seeing it here. So yeah. All right, so Rob is
Sorry,
away,
people,
so I'm
no,
gonna.
people didn't need to see me blowing my nose.
That is
So-
fair. It's just if you were away a little bit longer, I was going to have to start making up what I was talking about, or
No.
like going on to random topics. And oh, hey, I actually do have a random topic.
Oh, you got your plaque.
This is not like the hospital plaque. This is an Extra Life plaque. It says, "Congratulations on being a top fundraiser for Extra Life in 2023." So I got to figure out where to put this up. I'm thinking I might put it up in the garage. So
Put it where
Yeah.
you see it all the time. Good idea.
yeah, I don't really have room in here, so I will. Yeah.
Put it where it's gonna make you happy. Okay, swoop to Kohberger. Ready?
Yep.
I need the affirmative. Good. Okay, here we go. We're gonna be pretty quick, and I might not get through all of it.
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record, and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights.
Okay, so what are we arguing about? Kohberger, judge is very hands-on. And we had the big debate over the survey. The survey is allowed to go forward with the questions as they were originally posed. Judge dodged in his order, kind of pissed me off. I saw no problem with the questions, and I saw great frustration that I had and Ian had with how the prosecution was handling it and how the judge kind of jumped in. So now we have discovery disputes. The defense is arguing the state's not giving them all the shit they need, saying they have information, we need it. And they're like, fine, we will argue these things, but we want to do this under seal. And at this point, the defense is going, no, you've done enough, like leaking something here, leaking something there. This is not under seal, right? You make an argument for one motion, not under seal, that's favorable to you. But when it comes to something that I'm arguing where I want to make the damn point on my issue, you want it sealed. Like, we can't use this order to the advantage of one versus the other, which again is back to my main point of why the order, I hate it the way it is.
I
That's
feel
the
like the
context.
prosecution also kind of learned their lesson the last time, where he was like, hey, I want to make a big noise about this. And it's like, yeah, but, you say you want to make big noise about this, but at the same time, you're like, now that everything was, raised publicly. Yeah.
So that's what we're arguing about. That's context.
So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, it's more complicated and maybe prejudicial to one or the other. So I guess at this point we'll keep this open, but be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about. And some of those materials or potential evidence could be prejudicial to the state, or it could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there, that it'll be fair and we'll have been determined in advance. Okay, so keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that. Okay, so it really, I think at this point, it's the state's motion to close the hearing completely on May 14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGP.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the court's, the materials protected by the court's order, and so that one's appropriate to close.
Okay. Okay, I think I'm on the same page. Great. Okay, Ms. Jennings.
Thank you, Judge. So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing.
State doesn't have a right to a fair trial. The state doesn't have a right to a fair trial. It's not a thing. It's not a thing. The right is the defendants and only defendants. Sorry if it seems,
I mean, anything's a thing if you think it enough.
the state doesn't have the rights. Like this is not how that works. EDB speaks like this is where EDB is the prosecutor. This is where she's the retired prosecutor. Yeah. Ian and I will go to the mat against this comment, against these types of. No, the state has no right to a fair trial.
There's an interest in it, but there's not the same.
Right.
It doesn't
entitlement.
It doesn't trigger the same issues, right? So
yeah. Yeah, the state doesn't have the constitutional rights that the defendant does. The court has an interest in the dutiful administration of justice, but that doesn't allow you to kind of create a right for the state that the state doesn't have. Yes, perfect. Perfectly said. It's a public policy interest. You're right. Public policy interests give way to rights.
Feel confident that when the court does the same balancing test, it'll come to the same conclusion. For the record, since the beginning of this case, attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32. Concurrent with the fifth motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 74-124. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings, and this is just entirely inconsistent. To be clear, the state has nothing to hide. However, it's...
Why are we still talking about discovery then? Why are we still having these arguments? Where is the material? You're prosecuting. You have the obligation to turn this shit over. What are we doing? To be clear, we have nothing to hide. Okay,
but we're hiding it anyway.
I'm punchy because, yeah. Oh God.
Crucial that we protect, as we have been trying, the integrity of this case, and that we protect ultimately the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that,
she keeps saying the party's right to a fair trial. This is going to drive me nuts the entire time.
for defense's fourth motion to compel, Item 1, Subpart A discusses federal grand jury materials. Those are exempt from disclosure by federal law as well as Idaho Code 74-104 subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation, of which disclosure would, 1, interfere with enforcement proceedings pursuant to 74-124 subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124 subsection B and Rule 32 subsection E. And it would disclose investigative techniques or procedures which are exempt pursuant to 74-124 subsection E. For defense's fifth motion to compel, item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy.
No, you are not arguing this. Are you kidding me? I hate criminal discovery motions. I hate criminal discovery motions because they just. What she is arguing is that, yes, the state talked to a bunch of people. No, you don't get their names.
Privacy, subject to 74-104 subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I-2A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32 subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business and is exempt under the previously cited authority. Item 2, subpart B through L deals with the investigation, again exempt under 74-124A, subsection B and E, as well as Rule 32 subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order.
Fine. Okay. Let me explain. Ian, what's an investigative method?
So, for example, the police have techniques that they will use when they're undercover to look like they're consuming drugs without actually consuming drugs. If you ask them what those techniques are when they get up on the stand, the Crown will object, or at least here in Canada, it's the Crown will object and say, this is going into investigative methods, and it's irrelevant in most cases. So they will not he will not have to answer as to that.
For example, like here's a good one on this case. Let's say, hypothetically speaking, in the Kohberger case, this case right here, that, and I'm just giving you like an example of what the prosecution might have. If the prosecution has that the police, after consultation in department, decided that the best method of seeking out the identity of the defendant was to do a canvas. And the canvas, they were going to use these certain officers to do the canvas, right? They were going to use these officers to do the canvas because they looked the most like students. And they said that they were going to canvas the entire student body with these officers. And they were going to take interviews of various individuals on the campus. The investigative technique or the method is the decision, why the decision to do the canvas was there, the canvas itself, the selection of the officers in the canvas, perhaps certain identifying information of the officers, just certain. You know what it doesn't include? The information that they solicited or elicited from the prospective witnesses. That's evidence. Like, That's not methods. That's just a statement from a person. That's why I'm starting to get frustrated. Because the whole we're hiding this behind, or we're not disclosing this because of sources and methods.
Yeah, no.
From the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions, and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in the media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Yeah, thank you. May.
Before Ann Taylor begins, I know people have these opinions. Whenever I talk about Kohberger, I'm not opining on his guilt or innocence at all. I'm not. I'm pissed at the process so far. I see a lot of games that I don't like being played. And I know that people accuse Ann Taylor of doing something wrong. I think she was completely proper in doing her survey. I don't like games with discovery when the state is withholding information. And whenever the state says the state's right to a fair trial, I immediately get my back up. So
May 3rd might be a little quick.
Well, Your Honor, right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay, thank you. Thank you, Ms. Andrew. Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the fourth and fifth, and it's, I mean, some of the information it seems anyway. I mean, I'm not. It's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
Didn't the state just say something contrary to what the judge did? Like the state was like, no, we're not turning this over. And the judge is like, they don't have it. Okay. And
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things. And we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we file those under seal for expediency and saying, this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we file those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Brian's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho in the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave.
I see this. The reason she's citing federal grand jury cases, or I don't know. Right now, the one thing I will say is that she did appropriately state as far as whose right it was. So I don't know.
It open and let it be a public hearing, and that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Brian's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider that this isn't the state.
That was a mistake, Ann. Because what she just did was she fed Judge. Judge is going to now say, I am looking out for Brian's rights. I'm looking out for his rights so much that I'm going to disregard what his attorney is saying he wants. Sorry. Like I said, it's late. I'm a little punchy.
State trying to protect Brian's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context. That's what they're doing when they want us to do this in private and not let this.
Videos, I can see videos having a partial argument on some of those parts of the videos being sources and methods.
I mean, it depends on what's in the video.
Yeah. But not all of them.
State know about the full scope of the videos that are out there that they haven't given us. That is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Brian in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things?
I get it. Okay. State can't basically say, we're totally not going to talk about the actual thing itself, like the actual IGG information. That's totally protected. We're not going to tell you about the results that it reveals. We're just going to file this motion publicly to tell you that we're not going to talk about this magical secret stuff that revealed us, that told us about Brian Kohberger. So the implication is there for everyone to draw. And the defense doesn't have the opportunity to respond in public with, yeah, but no. Interesting.
Things they're not giving us. Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Brian have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear?
Ooh, Julia. I know that Brian Kohberger brings up a lot of people having a lot of thoughts. But it's not the defense's obligation to prove anything. Or
They don't have to
alternative
prove
suspects.
anything because if
Nothing.
at the end of the day you get to I don't know what happened,
It's-
Kohberger walks. If you
There's
get to I'm pretty sure it's Kohberger, Kohberger walks.
walks. The defense has no obligation whatsoever. They don't have to pursue alternative theories. They don't have to pursue alternative facts. They don't have to. They're playing defense. They're not playing offense. They don't have to do anything.
Yeah.
So respectfully, I know that Brian Kohberger and what happened in Moscow was horrible, and that there's a lot of evidence that they're saying the state's saying they have that points to him. But you can't shift the burden, and you got to be clear with all your information. You have to give it over. You cannot put someone in a position where they don't know what you're going to say at trial against them.
Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Brian's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that and that it starts a long time before the little clip that we've received.
Ooh.
To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents. But this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Brian has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public so that people can see it's not this neat little package. So people can start to wonder if Brian's innocent. Your Honor, Brian is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you, Ms. Taylor.
Bravo.
You know, I don't know where did it stop though. I mean, if we start pulling out all the potential evidence for the trial, before the trial, then does the state get to respond to that? And that's where does it start? I mean, or stop? It just is a roll of that. And so either side, okay, it sends to the public that it is not. You don't get the context. They don't have the context. The public.
See, and this is a good point. If Ann wants to say that the state's not being fair, does the state then get to say, we are being so fair that, look, we gave them this that clearly shows that their client's guilty? Where do you, and does that prejudice his right to a fair trial? So where do you draw the line?
You have the context. You want more context. I get that. But it's really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand Mr. Kohberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to answer that.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming.
Ooh.
Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or in their briefs that they disclosed, certain things, and it's a change. See that because both sides have agreed to seal a lot of these issues of evidence in the discovery, and so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like this isn't about the discovery. This is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about, and these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine, and I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Brian's right, but I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 from the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider too how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Brian has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is,
for example, a hearing about a hearing, like a hearing about a hearing about a survey about a hearing about a survey. Like that's what I'm saying. And Shell C, I get your point. But allow me to push back on this a little bit. Shell C says the thing that frustrates me is that the reason there's an order at all is the defense asked for it. Now they're complaining they can't respond to what happened before the order. Yeah. If you see a hole on a ship, you run up to that hole and you throw a piece of duct tape over it, praying to God that holds. But when that duct tape fails, are you stuck with the duct tape, or do you get to kind of figure out a new way? So I get it that when the defense is sitting there seeing all the public media statements, their initial thought is shut it down. But when it becomes obvious that shutting it down is actually causing more harm than good to the rights of the defendant, then at that point in time, you have to revisit the decision. So let's zoom and see if we get a ruling from Judge, or if he just ponders openly.
Zoom.
okay to get hearings set because deal with in 1 to 2 hours.
All right. Thank you. I actually mentioned that. I don't know, one of our hearings. That's what we need to do. I think it would be more helpful to, I guess, have better communication. Okay. I don't know. Maybe you are having good communication.
Oh, no. I can't. Ian, does this refrain sound similar?
Mm-hmm.
Like, why can't you guys just get along? Can't you give me stipulations so I don't have to make a ruling?
No, that is not how this works.
With each side, it is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson, and it just goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I
Yes,
have
that's
a
true.
lot of
That's
jury
a fair point.
trials going from here really to the end of the year.
Are they
So
the same
it's
though?
hard for me to say, okay, we're going to have it. I think I offered Thursday, like a Thursday afternoon. So
You would have fewer hearings if you made decisions. There would be so many fewer hearings if you just made the call.
I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean,
Let me see.
right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
okay,
Wait,
well,
hang on.
Your Honor's
What?
ability to
we'll deal with
I gotta
the
hear
13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end
Hang on.
and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig into exactly what is the problem with each one of these issues.
He wants his hands in the
All
pot.
right. So
He's like, I need to know
let's-
where
let's
exactly
talk about-
50% of this baby is.
Exactly. This judge, and there's some judges that are like this. Like, he wants to be in the decisions. Like, he is like, I know that I sit up on this bench, but I'd like to get down there at the table with you guys and really know everything. That kind of bothers me. I have trouble with this judge.
the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now. You got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect. And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witness.
The state's like, defense hasn't given us anything. And the defense is like, I can't give you anything until you tell me what you have, and I have to give you something in response. Oh my God. Ugh.
Is on the 14th too, as well?
Yes, Your Honor.
Okay. All right. So let's make it May 7th for disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that. And we'll have a response maybe May 10th. Is that sufficient?
Okay.
It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right.
Yeah, baby. Go judge.
May 10th is I don't know when I'm going to read all this stuff too, because it's 14th. So if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th.
Seriously? That's a
but
bad
also,
move.
The defense needs some space there too. And I don't think we want to push out that hearing.
Stick to the 3 days.
We have no idea what the defense plans on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with it the 13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm going to need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay.
I don't expect there to be reports.
Exhibits?
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, timeframes because we also have other things to do. But Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last-minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new.
Oh, we want to talk about the PowerPoint again? That's what we want. PowerPoint where your press release?
To you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay. Well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge. And I guess we've said before, it is more important to do it right than to do it quickly. If we have to have a trade-off here. And that includes fairness to everybody involved, including the court. And I would prefer that this not be kicked off, but we're realizing that we're essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
I'm expecting to have 2 on the 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses. On that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you. Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you don't have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff.
Yeah.
So that we can
do a trial.
Get ready for the trial.
Well, and Judge, I do for the record need to clarify the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on instead of being patient and
your attorney just argued that you are withholding material that you believed were privileged subject to such and such and such. You don't get it both ways. We've given them everything. We've held this.
Wait, because our discovery deadline is in September. That we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas due tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you many of the things that the defendant, when we talk to our people, they say that doesn't exist. So,
That's many. That's not all. Imagine there's at least one or two things that you don't want to give up. Anyways, we're, Santa, take a break. All right. Apparently we're going to have a hearing on the 16th or the 15th. Or we're going to push it out. Who knows? Maybe we'll have a hearing to have a hearing. Oh, exhausting. We're going to catch up on Super Chats, and then I'm going to get out of here because I am going to need medicine and sleep. Roro, I'm so grateful for the late night here. Need the distraction to stay awake. Taking care of my old cat, Zoe. Cancer tumors in her intestines. Oh, poor Paul.
Ooh.
Love this Law Nerd community. Y'all are great. Chat's great. Cheers, and hopefully a very swift recovery to Zoe. I know it's a manageable thing. It's not easy. And when pets are hurting, it's kind of like the hardest thing because you can't like make them not hurt. It just sucks. So cheers to you. Sassy me, the jury and the attorneys do not hear the sighing. Yeah, because it's on Zoom. That's possible. But we do. But that doesn't prejudice the jury. Niklas, good morning. Good morning, sir. It's my birthday weekend. Does that mean that you're eating something disgusting? Probably. My sister and her husband, my niece, my dad, and me are having birthdays within 5 days. Within 16 days, we have 12 birthdays. Well,
that seems like poor planning.
Yeah. Okay. 12 birthdays, 16 days. Happy birthday to you and, well, a majority of your family. Happy birthday.
And you and everyone you know, apparently.
Yeah. Go eat something disgusting because I know you will. And I'm going to laugh at it. Mispronounced name, Judge
Rob,
married Judge Reinhold.
Did I get a can of surströmming and like have it shipped to us in
It's Crime Con. It's not Rob doing crime against Ian Con. Because that will result if there's a can of surströmming shipped to a certain location where I am. It will become crime against Ian Con.
Oh.
Judge should marry Judge Reinhold for the memes. Okay. Tiffany Zabranik, if Brian Kohberger feels so strongly about it being open, shouldn't that be weighed heavily? Yes, actually it should. He's not wrong about the media bias. Couldn't they record it and release it with redactions or bleeps? Judge said he's going to start it closed, and we'll see how it goes from there. I don't know. This judge is kind of overly cautious and likes to be right down in the middle of it. 71208. Okay, I don't know about you guys, but I'm not having non-friends on Venmo, but they are on each other's. This is in reference to Katie and the witness. My name blanked. Karen Reed. So back up and watch. Apparently there's a Venmo connection that we might learn about later. Yellow Pill, thank you very much. If the state has the right to a fair trial, then what do they consider, quote, fair for the state? This is part of the reason that's not a
conviction.
Yeah, that's part of the reason it's not a real thing. They control the charges, adding on extra charges, grand jury proceedings, what plea deals include, if they even offer a plea deal. Yeah, they do. They also control the entire investigative process, what the officers do, say, or write down. I mean, they have all the leverage. I'm a goofy goober. Yeah, I actually participated in the survey when they did it. I didn't find prejudice me at all. What prejudices me is the idea of being a juror who acquits in a rural community. Prejudices me is the idea of being a juror who acquits in a rural community.
That you're gonna get judged by your.
You're gonna get judged, yeah. Like the fear that you would be known as being on that jury, regardless of how much protection was being made. Yeah. I can see that. XCDA, I'm so interested in the Kohberger Discovery hearing. It relates to my work, and I haven't actually heard the arguments. We're going to hopefully hear some more. Hopefully not all of them are closed. Happy Sunshine Dog Trainer Friend says those arm injuries look like tooth rips from canine teeth.
Yep. But just not, it doesn't feel like police dog. That's kind of the, but Chloe's not a police dog, failed out. So
to the end. Cub, what I heard was girls, you're both pretty. Now, please just get along. It's a little bit like childish, but I don't disagree. Jim Cox gifted 5 memberships. Thank you. Lady Di, thank you for the gifted memberships. Matilda, hello from the Netherlands at 5:53 a.m. It's 1:11 a.m. here. Matilda, hello from the Netherlands. Yep. I pulled that up already. Mike, thank you for the super chat. Jeremy Morton, that PowerPoint is still sticking in his craw. Oh, yeah. He was real quick on the PowerPoint comment. Yeah. John comment, I pledge a 200 super chat for Ian to open a can of Sir Stroming at CrimeCon. It's got to go to Ian then, because I will be punching him in the face.
Also, I know what pledges are worth.
Yeah, I know. Mary Ellen Froning says, I pledge 202 for the fish. Pledges aside, we shall not do that. Devin, hey, Devin. Thank you, buddy. And thanks for the birthday wishes. Just stopping and say hi. Be watching a replay in the shop tomorrow. Happy first 40 plus FNF. Thank you, Devin. Okay.
Old.
It is. What?
I said old.
I am old. I love it. It's fantastic. Year 41 is going to be pretty awesome. So to all of you who joined in and spent the 4.5 hours being here, 1, happy Star Wars Day. 2, thank you very much. For those of you who are new to the channel, please hit subscribe and don't forget to hit the like button on the way out. I very much appreciate you guys being here and spending your Fridays with me and my dear friend Ian. My hope is to be back next Friday. Until then, my hope is you're going to do like what Ian is going to do, which is get in the shop and make something, or just make something in general. Ian needs some leather working to do, and I've got to clean the shop up, and I do promise a shop stream before the shop is shut down for the move. So,
that's a big promise, because the move is going to be a lot of work. So
they're coming to pack the shop. I will be nervous Nelly.
I just know, especially because like your CNC, that's a big expensive piece of kit.
Yep. I will be rather anxious. I opted for the insurance.
I said kit, KIT.
Marie Burnquist, sadly, strumming are out of season now, but in the fall, I can send some.
I will take you up on that, because
you can send it to Ian.
I actually enjoyed the surströmming. Like, it was, I think my comment was, this is good, but it's not good enough to justify how much it cost for me to. There's a place that'll ship it overseas, but they charge an insane amount. So, but it was good.
And to those of you asking, the move is local. So just consolidating houses. That's it. So, all right, get out there, go make something, make the weekend great, have some fun, get some sleep if you need it, and get caught up. Until next time, I wish you all a happy weekend, and please check out Ian on Monday. Also, make sure to thank the mods. They do a phenomenal job. They were here for 4.5 hours when I was really hoping it would be more like 3.
Recap will probably be tomorrow evening. I'm just trying to figure out what time, because there's other stuff I'm trying to schedule around. So
perfect. Let us all know. We will repost the announcement. Recap is probably sometime this weekend, tomorrow evening probably, or a different time. And then Monday is going to be Monday. So like I said, check Ian out on Monday. When you guys show support in that chat, I get it makes me really happy. So please do that.
I was like, where's that going?
I love the support of the chat. I wish Mondays are hot. Mondays are tough. Like, I have trial on Tuesday. I'm not going to be there Monday. I'll be watching while I'm prepping trial. But
I mean, that's the thing. Monday is a rough day for all of this, but at the same time, I hear a lot of people going, Mondays suck, but you make them suck a little less. So it's like, I got to stick with the Monday, I think. So
Yeah, like I have a lot of work, so I can't join, but I listen in and I'm there in chat, like sometimes on 2X, sometimes, yeah. I love my Mondays. So, all right. Good night, all. Happy weekend. Happy Friday. Happy Saturday. And I will see you next time.